Honorable Hilton, Chairperson Designee of the New York City Loft Board. Welcome to our January 30th, 2020 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standard of safety and fire protection stated in Article 7B of the Multi-Dwelling Law, New York State's Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecute parties who violate the loft law and the loft board's rules. I will now turn this over to Elaine Balsam, who will make some announcements and then go into our rule discussions.
Thank you. So my first announcement is staffing. So we have a new Deputy General Counsel sitting to my right. Her name is Tina Lynn, and she came to us from Queens Legal Services, where she was a tenants' rights attorney since 2015. And prior to that, she was a Section 8 hearing officer at the New York City Department of Housing Preservation and Development. So we are very happy to have her here, and she has already proven a valuable asset, even though she's only been here a couple weeks. The next announcement has to do with the website. We have been told that it's going live today. We've been checking all day, and so far it's not live. But hopefully it will be live tonight at some point, maybe at the end of the day. So take a look, and if it is, start surfing. It's kind of cool, actually.
Yeah.
So
We've seen it demonstrated before. Last week we were trying to do that demonstration here, and it's still the same problems exist where there's just no Wi-Fi, adequate Wi-Fi connection to do it here in this whole building. So they weren't able to do it, and it hasn't been fixed. They're not going to. Oh, it's up. Are you saying it's up? Okay, great. Look at that. Spoken to me. So it's up. But take a look. You know, not now, but and provide any feedback to Helene, who will. You know, I'm sure there are, some stuff that needs to be corrected or changed or whatever. But just let Helene know, and we'll perfect this. The fact that it's up now puts it squarely on the DOB's end to make changes.
oh yes, it is.
All right, so do it. Finally got this up, and so we can quickly make any changes that has to happen. Or suggestions. Got some nice, cool pictures up. I like the pictures. All right.
All right. So that's the website. Yay. Okay, so rulemaking.
I'm sorry, before we get into that, I just wanted to follow up on we've got a couple of open items that have kind of trailed their way into 2020. One being the self-certification conversation that Julie initially raised, and I was just curious if there's an update on that.
There's no update since earlier this month, when we met. And I haven't been able to. I had some stuff that happened with me personally, so I haven't been around so much. But I will do that immediately after this meeting. Follow up, and I'll send you, the board, an email as to what's happening. I just have to confirm what's going on. All right. I apologize for that. Anything else, Chuck?
No.
Okay, so we're going to tackle 209 today. So that is on page 172. 209B is in the way, I should say. I mean, really, it starts with the whole pages before, but everything before that is just a deletion except for the title on page 169. So the text, the new proposed text starts on 172. So line 1, so paragraph 1, we've already talked about that at great length, so I'll move to line 2.
Forgive me, but I'd like to talk about it just a little.
Again?
Well, I'd like the line we're talking about as a protected occupant must be a natural person. And I'm still not clear on the necessity of this.
So if the unit is supposed to have people living there, corporations, although they're legal entities, they're not people. We want people in these units.
Can I ask about number 2, the highlighted one that you said we would talk about a lot?
No.
No, number 1 we talked about a lot.
Oh, number 2, no.
Number 2, no. Number 1 we had, I don't even know how many hours.
So I guess partially my concern stems from the fact that a lot of these original bogus leases were sometimes signed by an entity that the tenant might have a corporation or an LLC.
That's okay, but the protected occupant is going to be the tenant.
So, well, yes, and that's part of where, in my linear thinking and my rabid adherence to the way we did things for the first 30 years, my concern is just that now, for example, that we're going to, we currently have all this case law that's evolved with regard to who the prime lessee is. In the case of the original lease that allowed people to live there because the owner and the proposed tenants kind of winked at each other, if the only lease is in the name of a corporation or LLC, it confuses me why we need to have this sentence.
So if the lease was in the name of a corporation or an LLC, then the corporation or LLC would not qualify for protection, and the prime lessee would not be protected because they're not a natural person. So the tenant would be protected. But that's how it would work.
Mm-hmm. Okay.
Isn't that the result we want?
Well, you know, I have never in my time on the loft board seen an application filed for protection as a residential occupant by a corporation or a dog or a cat. So to a certain degree, this seems like such an obvious statement that
Chuck, it's coming. I just heard on the news this morning that a goat is running against a dog for mayor in some town, so it's coming.
okay.
Is that business
We have,
applicant or something?
but we have had owners that wanted to register corporate tenants as opposed to the people. So we wanted to make it clear that they need to register the people. And it's the people that are protected, not the corporation.
Right, okay. And person doesn't suffice, it's natural person as opposed to unnatural people?
Because the definition of person within the definition section includes more than just a person. It's broader and includes legal entities. So that's why it has to say natural person. We've already had this discussion.
Well, yes, I recall, and we had a big debate on this last February 14th, so some of this stuff has been sitting around for over a year, so.
But I think natural just means you have blood running in your veins.
Yes.
Yeah, I think that's what it means.
Okay, all right.
Okay, so that gives us.
So,
Yes.
you know, I had a discussion years ago with, when I was teaching with some Asian students. And when they wrote human being.
Right.
So I asked them, why do I hate human being? Why don't you just write human being? And they said, no, professor, human being, right? And they felt that that was the proper way to describe a person. So why don't we
Because
say human being?
Natural person is a legal term.
It is really?
Yes.
Okay.
Yes, it is a defined legal term.
Who defines it?
The law
Really?
over the years in general.
All right.
All right, let's
Keep the
move on.
discussion.
Human being may be a space term or something.
Okay, 2. So this actually should say placeholder for prime lessee and their spouses / domestic partners with lease in effect being protected occupants to the exclusion of everyone else if applicable. So this was something that the board had not decided on, so that's why it's there as a placeholder. So you have to decide if you want to go that way or not, and there was a lot of discussion one way or the other. It's entirely up to you.
And what
So,
line did you just read from? What was that?
2. Placeholder for prime lessees, it should actually be prime lessees and their spouses and domestic partners, because we had already agreed with that. So it's placeholders for prime lessees with lease in effect being protected occupants to the exclusion of everyone else, if applicable. So this is the concept that the board had talked about, because there was pushback. I don't know if you were here then when Mr. Carver was talking about Anne Fran and, you know, do we want, if Anne Fran happens to live with them, do we want Anne Fran to be covered and roommates and et cetera. So that was the back and forth. So I just left it in there for the purposes of discussion. When you decide what you want to do, then we'll either put in text that says that, or we'll just take this out altogether and renumber the rest.
Okay. I did have something to say. I'm just trying to find that exact line she's reading. Can you?
Well, it's this one.
It's the highlighted one.
But it doesn't
But
have
Elaine said,
reading it out loud. Oh, I thought you had it for us, but when you're talking about the
No, it was just the concept.
no, she threw in
No,
spouses
I
and
threw,
natural
it should
person.
say prime lessees and their spouses, domestic partners, because that was something that the board had already agreed on.
Okay, yes, I like that, but I remember that there was a debate with Carver about, I think you were going to research it in the law staff, a lease that's expired, right? So I know a case of a guy who lives in LA and sublets, and he hasn't been there for 5 years. And he has an expired lease from 10 years ago. Does he have power? I mean, he's not been around, his lease is expired. Is the expired lease has weight over someone else?
Well, I think you're asking two different questions.
Yeah.
So the first question is, under our rules currently, would he still be protected? Yes, because the definition of prime lessee includes somebody who had a lease and the lease expired. So he'd still be considered a prime lessee under our rules. Theoretically, he's not a protected occupant under our rules because he hasn't been living there and he hasn't, from what you're saying, complied with the subletting regulations. He's been gone too long and didn't reclaim the space. As to whether or not the provisions of the lease carry over, which was one of the things that Mr. Carver had asked about, and we did have somebody research, but I'm going to ask Tina to address that because she's in the best position.
Yeah. And the answer is, well, unsatisfactory, it depends, but in theory, yes, it should. When you have a written contract and it lapses, I mean, usually that doesn't renew by itself, but in landlord-tenant, they read the terms and conditions of the lease should continue unless either party does something to change it. It's sort of an implied contract between the two of them. So the terms should carry over unless someone does something to suggest that there's a change in terms.
But it's a month-to-month tenancy, right?
Yeah, it's month-to-month tenancy, but again, I think it would depend on the specific contract that we're talking about, but in general, just and very generally, courts have read terms into leases that have expired, even when it carries over to month-to-month.
Okay. I mean, I do know, I make rules best when I'm thinking of real examples in my life, so it helps. In this case, I think they might even, what if you have a landlord who has a loft building and they're making new leases with tenants that are not IMD tenants, and the building is not covered. I mean, their units are not covered, but they're making leases for residential living.
So
They're probably still doing the same like phony commercial lease, but people are living in that apartment.
So if they're not covered units, then those are illegal leases. And,
Illegal occupancy.
right, it's illegal occupancy.
Yeah, it
You
is.
know, like if you have 5 covered units in the building, but there's actually 10 apartments, so you have 5 legal residencies, even though they're units haven't been legalized, right? So you have 5 legal residences, and then you have 5 that are illegal.
Right, so
I
those-
guarantee you the leases, the illegal apartments are not for residential.
Right, they're probably that commercial template boilerplate one. So what, does that have power though? I mean.
So I think it would be up to the people that are in those units to file for coverage, which they could now do if they were there in 2015, 16.
But if there's an
And ask for
absentee
protection.
crime, guy with a lease who lives elsewhere in another
Right.
state and isn't, like, does he still have more weight over the, he's not there as, I don't want the unit
So-
to be empty, right? We don't want to kick out both parties and have an empty apartment.
So one of the reasons we would want to be able to cover the
People living in the.
the people that are living there, that are the sublessees, right? One of the reasons that we would want to cover them is because they're the ones that are there, and they could bring a proceeding, and the owner actually, I think, could sue them, could sue both of them, right? Well, I guess, yeah, because if they're not, if it's the prime lessee, if it's not the prime lessee's primary residence and it's a covered IMD, right? The law requires that
It's
it
not a
be
covered
there.
IMD.
It's not a covered IMD. Oh,
They
well,
could apply.
I don't know, our rules apply to IMDs.
So if you're,
So,
just for people applying, can they apply? Can that subtenant apply?
yeah,
Even though there's some lease that exists somewhere that someone else has?
yes, it'll be an issue in the case, but sure. I mean, we've had that situation where you had, like, I think they call them ghost tenancies?
Okay.
Ghost tenancies?
Yeah, I mean, I think.
Illusory tenancies, yeah.
Illusory, yeah, I think I'm speaking of a case I know, but I feel like this speaks to
Yeah.
many cases. So thank you for clarifying that. Okay, so a case can still proceed. I just want to make sure our rules don't block someone.
No.
from living
No.
ever.
So the question for the board is whether or not you want to allow I call it the prime lessee and their spouse, domestic partner, trumps all. So, do you want that or don't you? If you don't, we'll take this out and move on. If you do, then we won't. Also, there's a question about the definition of prime lessee, and that would probably be less important if we don't have this clause. So, I mean, you still need a definition of what it is, but changing it to just say somebody with just the lease in effect, you wouldn't have to change the definition if you don't have this particular clause.
Well,
So-
I guess my preference would be to leave this open for the moment until we go through the guts of the issue. And I apologize to the members of the board, but in my mind, at the moment, the staff has 4 attorneys on it now. And I think you have another slot to fill, but our Deputy General Counsel is new and I gather experienced in housing court, and we have another new attorney. So I will try to very succinctly summarize the problem I have with this section the way it currently stands. When the Loft Law was passed in 1982, rather than being a series of numbered rules, the board actually adopted a sequence of regulations that later became recodified and placed under New York City rules. The regulation, which this section was the regulation which became this section was originally called Rules on Subletting, Subdivision, and Assignment. And it was developed only to address issues where there was an active fight over who was the protected occupant, where there were competing interests among residential occupants. So, for example, I happen to have sublet my loft for the entire 1980-81 window period to someone else. There were no rules as to how long I could sublet. Everything was highly informal. So lo and behold, the person who was there during the entire window period said, I'm the protected occupant. I'm the one who lived here during the window period. The other circumstance that came up was, well, there are two other circumstances. So that's subletting. Subdivision was where I was an entrepreneurial tenant, and I created 2 or 3 units on a floor. I put the capital risk in and fixtured the place, and became, as the subtenants called them back in the day, a mini landlord. And the question there was how to determine how the subtenants would come into privity with the landlord, what the rent would be, because I was paying, in those days, $1,000 for the floor, and I created 3 other units, and they were each paying me $800, so I was coming out $1,400 ahead every month, which in my mind was fair because I'd made the investment and put in all the fixtures. And the third issue that rule was intended to address was the question of assignment, because frequently what happened is the tenant who was leaving sold his fixtures or her fixtures to an incoming tenant for a fixture fee or key fee, which is how I happened into my loft in 1975. It was, my loft is 1 floor, there's nobody else there, there's no subdivision questions. So a great deal of this rule, now rule, then regulation, the entirety of that rule, and portions of it still read well when you read it for that purpose, related to solving these questions of competing interests. And what is now Section 205, registration, was the rule on, that was at the time called coverage, who's covered. So for up until about 2014, so the first 30 years of the loft law's existence, if 2 people shared a unit and they applied for coverage and they could both prove that that was where they lived, they were both considered covered occupants. The fact that one of them signed the lease with the landlord and the other one didn't was ignored. And what's happened since 2014, or perhaps a little bit prior to 2014, this rule has been viewed as addressing not only contested space in terms of subletting, subdivision, and assignment, but it's also now become part of determining who's a protected occupant. Particularly the question of who is the prime lessee goes also, and is the, if I was a prime lessee and the lease is expired, I can see the logic of that applying to a commercial lease. I rent an office for a year and there are these provisions, my lease expires, and now it keeps me on month to month. It's an office, I'm renting it as an office. I was a residential tenant in a 2-family building, and I had a lease, and the lease expires, but I continue as month to month. But here, at least in the early era, and I think to a large degree in the current era, if leases were given, the lease included terms that never apply. We both agree that this is going to be an art studio is permitted by law. That was the most common term of art that was put in the standard Bluebird loft lease. But oftentimes it would include, and I swear I don't live there, I really live with my parents in Texas, et cetera, et cetera. So reading 208 again in its entirety today, I am still...
209?
209, I'm sorry.
Yeah.
Reading 209 in its entirety, it's a little bit like you know, that thing they make at Thanksgiving where you stuff a duck inside a turkey. Yeah, it strikes me that it's attempting to address two sets of issues in one rule, and I still, reading it this week, I thought to myself, you know, whatever we want to do, and I grant that the way it worked for 30 years did not take into account the bigger buildings in Brooklyn with more units, and it did not take into account people who, you know, in the old days, as I've mentioned, you know, I lived in a building up in Morningside Heights with a guy who rented it when we all went to college. He was still subletting that unit 20 years later, and he lived in the Albany area for those 20 years and making a profit. I think that's reprehensible. I'm not out to defend tenants profiting off the landlord's property. And that's why in its original conception, this then regulation was intended to address one set of circumstances. Now it's trying to deal with two different issues. I almost feel like the part that sorts out who's protected and who's covered in instances where there's no battle between the parties should actually be moved into 205, and this should have its original purpose, because it's bloody complicated the way it weaves in and out. So I question why we've got all this in one place. And I also, in this instance, since the lease was a sham to begin with, to say that, and that lease may have been, we've done cases where somebody had a lease for 1 year in 2005, they got covered under 2010, and now it's 2020, and we're going to look back to that 1 year lease in 2005. It just, it doesn't make sense to me. So I'm sorry, I know some of you have heard me sing this song
No, it's good for you to
far too many times.
explain it all. I'm wondering, is that possible to parse
Sure,
out?
I mean, yeah, we could definitely move some of this somewhere else. I mean, I'm fine with that, I don't think that's a problem. I think one of the reasons that we wanted to limit it just to the lease in effect is because there are contractual expectations, and you could wind up with constitutional issues. I think the law department was concerned about that. And so, you know, I think we felt that if we had to limit it somehow, we would limit it to when the lease was in effect, and that's it.
Well, and in that instance, and bear in mind that by the time the original Loft Law passed in 1982, almost all of the original 5 and 10 year leases had expired, and many, hundreds, literally hundreds of buildings were in litigation. Everything was being determined based on decisions in Housing Court and Supreme Court. There were buildings where the landlord had turned off the water in the building. I mean, it was a very peculiar situation. It is different today. But I think if we did tease apart the significant portions of 208 that are involved with competing interests among occupants, and had that stand on its own and put everything else, whatever we decide, in 205, it would be a lot clearer.
Fine.
And I also
That's not a
question,
problem.
and I also question whether we want to, how much weight to give to an expired lease, given the questionable nature. If I signed a lease that expired in 1997 that said I wasn't going to live there,
I'm not in favor, I'm in favor of saying that if the lease expired, the contract is done, and the fact that there, you know, is some sort of legal mechanism where it might continue, I think the circumstances have changed, particularly in a loft law case, a loft law coverage issue. So I'm not a big fan of continuing if the lease has expired. I think, you know, the contract's over, and you move on and cover as many people, you know, protect as many people as possible. So that's why it says prime lessee with lease in effect. I think when the lease is in effect, we're stuck. You know, there's not much we can do about that. That's a contract, it's a legal a legal contract, and everybody has rights under that contract,
Right.
and, you know, there's not much we can do about that.
And I agree, certainly, when the law passed initially in 1982, there were still leases in effect between the prime lessee and the subdivided space tenants. And yes, those leases were allowed to play out, and that's appropriate. The subtenants wanted the loft board to break the leases and to
Yeah, and that's.
jigger the rent immediately, but as you said, that gets into contractual issues that it made sense to, you know, that was, the battle over subdivided space was one of the most painful parts of the institution, the original loft law, and the landlord didn't want necessarily to have all these tenants
In the building.
have privity with. Chuck put his 3 subtenants, all of a sudden the landlord's got to deal with Chuck's problems and the other 3 people as well. The landlord was not, but the carrot that was given the landlord is we're not going to recalibrate the tenants' rents.
Uh-huh.
So the windfall that was going to the prime tenant now goes to the
To the landlord.
landlord.
Yeah. So, you know, what does the board want to do? Should we draft something that says that the prime lessee and their spouse or domestic partner with a lease in effect is the protected occupant to the exclusion of other residents?
Okay. So back to that, I get it, now
Yeah.
it's like current in effect lease.
Mhm.
So that would be a couple, or it could be an individual who's subletting, has roommates because they can't afford to
Mhm.
live there alone.
They can still have their roommates,
And
it's just that
if
they're not.
they did all the law expenses and they built out the space and fought for IMD coverage, now their roommate, who might have only been there a year, could be equal protected tenant with them, right?
If the lease expires? No, this is when we.
If we didn't say this.
If we didn't say this, that's correct. Yes.
And that would mean that, I think someone explained to me that would be like a couple being divorced. It would be figured out in some other court if they end up getting in a fight.
Yes.
Not,
Yeah, and I think that another example that was given was where somebody moves in, you know, like a roommate, somebody takes in a roommate just prior to when coverage is granted. So like maybe, you know, it's one thing if you've had a roommate for like 10 years, you probably know each other pretty well, and it's either gonna work or it's not gonna work. I would think after 10 years, well, you never know. But, you know, what if somebody moved in the month before, right? And then coverage comes down the next month, and everybody in the unit is protected, and then maybe it doesn't work out so well, and now you have a real problem because now you can't get rid of that person. So,
Right.
and again, you know, whatever you want to do is fine, but those are some of the examples.
right. And I remember we talked about rewriting rules, the goal, the mayor's goal, our goal was to cover more people.
To protect more people.
So if you protect more, then you would not do this. Because,
Well, I'm concerned about not doing something for when the lease is in effect. I am concerned about that. You know, because pretty much the prime lessee controls what happens in that unit when the lease is in effect. It's their, in essence, their property for that period of time.
Well, I think one of the things that we need to think about there is, and again, this then rule, this then regulation, now rule, was written with the idea that Chuck created separate units on the floor, which is different from circumstances that we read about and have heard about in some of the larger footprint buildings in Brooklyn.
Right.
10th Street comes to mind, where there are 7 of us, and we're all here, and there are 2 bathrooms and 1 kitchen, and
Right.
and whatever else, and we all consider ourselves to be family.
Right.
And that's very different than I'm the landlord of these 3 little units that I created. It's a totally different issue.
Right. I mean, at some point, the rule was amended, and it now says, protected occupants and the other thing, privity, subletting, blah, blah, blah. So at some point, there were amendments. But the question is, what should we do now? Right, we have a slate. What do we want to do on that slate? What are we going to write on that slate? And we need to resolve it. And if we can't resolve it, then let's leave the rule as it is. Just say, amend B4, the current B4, to say prime lessee and their spouse or domestic partner, and move forward. But I think, I would rather that the board be able to come to an agreement and make some of the changes, because I think that they're good changes.
Well, I would encourage considering, taking a step back and considering taking those changes and putting them in 205.
We can take that. We
Right.
could stop this on line 18, page 173. So take 172 down to line 18 on 173 and put that in the other section. I'm fine with that.
In 205.
In 205.
Right.
Yeah, put it into, we'd have to rename 205, but yeah, put it in 205. And then we could move down the title, go back to 169, right? And we would change it to, we would change the title back to privity, subletting, whatever.
Right.
Okay, so, I mean, that's, moving it isn't the issue. It's, even if we move it, what should it say?
Right.
So, we have 2, which is a placeholder, but what about the rest of it?
I would submit that the way the Loft Board originally cut the Gordian knot of subdivided space, sublets where I was here the whole window period, so it's my unit even though you developed it. I think that works, and it's been upheld in courts. And if it stands alone, then this becomes a lot easier to read, because you don't keep stumbling into stuff that really is all about that fight, not the question of there are 8 of us in the unit, who's covered. And I'm happy to explore that as a separate issue, and part of why I think it's much better to have them separate.
Okay, fine. That still leaves us with the text from line 1 on 172 to line 18 on 173. And is that what we want to move into 205? Because I think that accomplishes what you want to accomplish. The subdivision stuff is basically staying the same.
Yes, I agree.
So, except for the little rewording of what is now subparagraph 6 on line 19, the rest of it is just going to stay the same with some minor additions to include 281.6.
Yes.
So, and I think that's fine. But what do we want to do with the first part, right? It's up to the board. The legislature didn't define occupant qualified for protection. They left it to the board to define by rule. I think everybody feels that the rule that we have is not adequate. So what do we want the rule to be? And this reflects, I think, all of the discussions that we've had, including the points and the lines and the whatever. And so is this okay? And then do we want number 2? And if so, we'll flush out some language.
This whole thing gives me a headache.
You're not alone.
When the loft law first went into effect, there were a substantial number of artists that didn't want it because they had all kinds of special deals going on with the landlord. I think there was a case here that one of our predecessors, Cynthia Loretta, mentioned to me about somebody that I also knew at the time who sublet a whole bunch of spaces in his building which he didn't know. I'm also curious about the sublessee. How many are there? Are they all family, as Chuck mentioned? The rule says by blood or something or other, whatever it is, it's limited. But I don't think it is limited. And I think that for the artists that objected to the loft law really wanted to get as many people, partially for their own
Profit?
profit, you know. So I've been, this has been going on in my mind since the beginning, since I started sitting here, and I don't even know what to make of it at this point. I must say that to suddenly see the whole idea of it, sort of, it just boggles my mind every time I hear this of subway C. I can understand it to a great extent, and I don't particularly like it.
Well, I mean,
That's not a good thing to say.
but there are legal sublets. I mean, sometimes people
Yeah.
travel and they can't afford to keep the
No, it
apartment when they're
certainly is.
traveling, and
I
so,
understand.
they're gone for a year and they sublet. There's
I
nothing wrong with
understand.
that.
I mean, we had one case here where a woman, an artist, got a temporary job in California, right, and she sublet her place
Right.
and left some furniture and was able to come back, right? So I
Right.
certainly could understand that when it's as clear as that.
Right. But the focus for me at this point isn't the subletting stuff, because the subletting stuff is basically going to stay the same with some addition of dates and things that we need to add for 281-6. The focus is before we even get to the sublet, the focus is who's the protected occupant, who's the occupant qualified for protection.
So let's break it out as a hypothetical. We're dealing with one unit with one front door,
Right,
one kitchen,
right,
one or two bathrooms.
right.
But everybody can come and go. This isn't 4 separate units on the floor with
Correct.
4 separate. So how do we deal with, and this seems to have been, this type of arrangement seems to have been more popular in the newer buildings than the older buildings, partly because they're bigger, probably also partly because the
More
rents were a lot
expensive,
higher
yeah.
from the get-go. So I needed to have room. So what I hear us saying so far is, okay, we'll look to the lease and we'll take the prime lessee into account and spouses and significant others,
If the lease is still in effect, yes.
if the lease is still in effect.
Right.
And if the lease is not in effect,
Then it's whoever was there on the date, on the effective date of the law, right? And if they came after the effective date of the law, there with consent of the owner, and if they used the unit as their primary residence on the date they filed the application for protected occupancy. That's what this says. And that's your point, the date.
yes.
That's June,
June, for the current window period, June 25th, or is that the first one? I'm sorry, I think it's June 25th, 2019, yeah.
okay. And then, so that's clear, someone's living there. And then if someone moved in December 2019, with the consent of the other roommates?
With the consent of the owner.
Of the owner.
You know, because sometimes one person leaves, another person comes, and they enter into a lease with and the new person enters into a lease with the owner. You know, if the owner isn't bothering to buy out the person that's leaving, then the new person should be the protected occupant.
Assuming there's one person.
Yeah, I mean, you could always have, I mean, prime lessees, it's whoever's a prime lessee, right? I mean, you could always have. Yes, assuming that there's one person. I guess it gets more complicated if there was one person that was there. You know, let's say you had one person who was a prime lessee who had 3 roommates. The lease has expired, the prime lessee has left, and that left the 2 roommates, and then one of those 2 roommates left, and then the other one came. But I think you could still sort that out based on the language of this rule.
Yeah, the way this, I think these rentals work, well, at least from the knowledge I have, the guy's remote in California doing his thing. He's renting out to people, they're moving in and out, and they're finding replacements as they
Yeah.
go.
Yeah, running the unit was the term at 401Y. I'm running the unit.
Yeah, and that's how it works, so that if they're not if they moved in December,
I think the question in that situation would be who had the consent of the landlord, because it's after the effective date of the law. So if you have somebody who is running the unit, right, roommate, an ex-roommate of the prime lessee because the prime lessee's gone, right, and you have somebody who's running the unit, who's the landlord collecting rent from, who is the landlord dealing with? I think all of those are going to be issues of fact that you're going to have to determine. And if you have one person who's basically living there, please, you have to be living there, and in charge, right? And that's the person that the landlord is dealing with, then probably that's going to be the person that's the prime lessee if everybody came later.
okay, and what if that person's Venmoing, like people are Venmoing him cash and he's in another state and they're living there?
Then it's up to somebody who's actually living there to assert that claim, right? I mean, somebody has to bring that to the loft board or the owner's attention and say, hey, you know, we have an illusory tenancy here.
And then the one other piece I want to, proving the IMD unit, you can just vouch that this person was here during the window period. Like if we're talking units that are not yet IMDs, where we're trying to get IMD coverage and we're trying to get.
This rule would apply to both, right? So this rule 3 says if you're living in a unit that's not an IMD and you want to be protected under the loft law, you have to apply either before you apply for protected occupancy or at the same time. You have to apply for coverage for that unit as well.
So coverage for the unit is easier than coverage.
Yes. Yes.
Because you just have to get someone to.
Well, you have to prove all the coverage things, right? I mean, you have to prove that there were 3 units independently occupied during the.
Well, if the
window
building's
period.
already covered, if the building's
If
already.
the building's already covered, it's easy.
To get the IMD covered.
If a building is covered, an IMD covered, and the prime lessee moves out and has 5 subtenants,
Mhm.
then what happens?
So I think it depends on when they, based on how this rule is drafted, I think it would depend on when they came and who's dealing with the landlord or who the landlord is dealing with, right? So if there's 5 of them left and one says, okay, I'm going to be in charge, and everybody else agrees and they all pay rent to the one person, and that one person then pays the landlord, then maybe that's the person that should be the protected occupant. But if the board says no, and it should be everybody, that's okay too. I mean, I'm okay with protecting more people. I think everybody's okay with protecting more people. You know, but it's going to create, you know, protecting more people is going to create a whole host of issues. But that's okay. So you deal with those issues.
Well, it seems like whatever we do, we're going to create a host of issues. It's just a question of whether they're over here or over there, so to speak.
Yeah. Yeah. I mean, I guess if the prime lessee left and then you have 5 people left and they all become protected, you know, I guess that could be kind of thorny if you're talking about sales of rights. But, you know, we have cases already where we've said, you know, you have to buy, whoever's protected, you have to buy all of them out. And I guess we could entertain applications for protected occupancy and see how the cases play out. I mean, it isn't written in stone. Just because we do this now doesn't mean we could change it later. Not that I'm advocating that we should continue this, but it would be nice to come up with something that's workable and that fits everybody as best as we can.
I just want to ask one more question, sorry, and then about that person who was in December, because as we get further away from that date, June 25th, 2019, there's going to be like hundreds and hundreds of people, like as the years go by.
Right.
So that person, I'm just trying to protect, well, think from the perspective of the person with the least power in any situation.
Mhm.
So that would be that person who moves in after the 25th of June.
Right.
They could still be a roommate there.
Of course.
They're just not protected.
Correct.
So they're not being like evicted.
That would depend on whoever is running the unit, right?
Right.
But yes, they could still, I don't think that there's any reason that they couldn't live there.
As long as one of them is protected. I just don't want it to disappear where all the people living there disappear and then it's becoming market rate. Because that's like.
There would have to be a deregulating event for that to happen. So I guess if everybody abandoned the unit, right, the owner could then file an abandonment proceeding. That could happen. Would it? I don't know, but it could.
Is there anywhere, speak up. This is more like is there anywhere in the law in general where a person is multiple persons? So if you had 4 people, would there ever be a scenario where they're one occupant?
Not for protected occupancy purposes, but if they were all, you know, I mean, the owner they could all be protected occupants. They could all qualify as protected occupants. Right? Let's say that there was a prime lessee, the prime lessee left, and the lease is no longer in effect, and then 4 people that are living in the unit filed for coverage, and they were all there prior to the effective date of the law. All 4 of them would qualify as protected occupants. And I think that's what we want. I think that's what it was before, and that's what we want to get back to.
We took a step in the wrong direction with 79 Lorimer Street, as I recall, where the tenants advocated for more people being covered than we found to be covered.
I think that we had had a line of cases that were evolving, and you know, you can't just say, well, because you want it, we're going to do it. You can't just say, well, we're going to ignore our rules and how we have interpreted it. The proper solution to the 79 Lorimer paradox is change the rule, and that's what we're trying to do.
Well, there are those who, starting in 2014, I have had my heels dug in and bitched about every one
I
of these.
understand that, but this is where we are now, and the board's a majority, you know, the board is a majority, and it didn't go your way, so let's go back.
Right, no,
Let's see if we can go back.
I'm not bitter about it, I'm just, because I spoke to somebody this summer before Chapter 41 passed, who said, you know, I developed this unit, I've had a variety of roommates, I've explained to each of them that I put all the investment into this, that they're just a roommate, I've asked them to sign an agreement, that they won't apply for coverage under the loft law, what do you think my chances are? And I said, I don't know, and I wouldn't give you any advice, I'm not a lawyer, you know, but even free legal advice from a photographer I wouldn't give you, because it's, I don't know. So obviously they're, particularly with these bigger units where you need roommates to make the rent.
Right.
I grant that it's not, you know, in 1982, and gas was 49 cents a gallon, it was a wonderful world. You know, and times was 50 cents, but even I have to admit those days are gone.
But nobody's saying that you can't still have roommates, right? The issue is who are we going to treat as the protected?
Are the roommates number limited to 2?
No, there are, well, you would know that.
There's a larger of the one roommate if there's one person on the lease. That's what the law says.
What is it?
If you have one person on the lease, you're entitled to have one roommate, and the roommate's family as well. So you can have your family, if you're the only person on the lease, you can have your family live with you, and you can have your roommates and your roommate's family. If you have 2 people on the lease, it gets a little dicier. It's unsettled. It's not as clear on that area.
The multiple dwelling law says up to 4 boarders, right?
That, I'm not sure. Oh,
Yeah,
it
it
does.
does.
Roommate law, okay.
Nobody says,
And we've got a case in 10th Street where the judge said 70 are a family.
Right.
Well, they were a family though, that's how that.
Well,
but
They were.
they're a modern day
They were,
family.
yes, they're a modern day family,
But
yes.
how do we get the multiple dwelling, it's really interesting.
I'm
Yours
saying
is
it's
based
real
on-
property law, so
Right.
that's looking for section. I'm
RPL.
not sure what the MPL is referring to. It might be a safety issue. For
Yeah.
your RPPL, that's what the roommate law says.
It
Yeah,
could
no,
be
the-
one person and their family, so it
Yeah, the roommate's
affects
family
more
than
than
one
one
of
person.
them too.
Yeah.
Assuming it's not overcrowded.
75 Lorimer Street,
79.
on each floor, there were 5 units, 5 people, 1 kitchen and 1 bathroom.
Okay.
You remember that?
Huh?
You have a good recollection.
Your son lived there years ago. And I had dinner there several years ago with some guy who made a Persian meal. And so once again, I saw this same building with 5 units, 1 kitchen and 1 bathroom. And there's nothing wrong with that, as long as everybody is comfortable.
But that's not the issue of people being comfortable. It's the issue of who out of those 5 are we protecting? Are we protecting all of them? Are we protecting one of them? How many are we protecting?
Yeah.
And what are the criteria that we're
That's a
using?
big question, but we can't protect 5, right, according to
could.
the law?
The way that the rule is written now, okay? If there's no prime lessee and there were 5 people, 5 residential occupants there on the effective date of the law, they don't qualify. That's what we do right now under the current rule. So yeah, we can protect 5.
So if there's no lease, and there are 5 residential occupants, all 5 are protected.
If they're there on the effective date of the law, yes,
Whoever was there,
yes,
right?
Yes.
But if there is a lease,
right.
the protected person is the primary leaseholder,
The prime lessee,
prime lessee.
or prime lessees, because there could be more than one prime lessee.
And to complicate
And their
matters-
spouses and domestic owners.
complicate matters further, if the lease has, more than one names on it,
That's okay.
all of those folks are protected.
Mm-hmm, yeah.
All right, so what are we arguing then?
Why don't we just leave it the way it is?
What are we arguing?
Well, because the current rule says the prime lessee is the protected occupant to the exclusion of well, it doesn't exactly say that, but it's been interpreted to say that the prime lessee is the protected occupant to the exclusion of everybody else, and the prime lessee includes, the definition of prime lessee includes whether or not the lease is still in effect. So I think that's Chuck's example.
That's what we need to do, we take that stuff out of there, right? To clarify so that everybody is protected. No?
Well, that's another way to approach it, is to leave it as is and take out the, well, I would still want to I would want to get rid of the except language, because it says, it starts with except as stated below, and then blah, 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 and that's caused a lot of confusion. So I would still want to reword at least that part. But yes, we could certainly change, one way to handle it would be to change the definition of prime lessee to say it's only when the lease is in effect. And see what happens. I mean, maybe we'll get a court challenge and we'll lose. I don't think so, but
Where's the except as stated below?
209B1?
In the-
209B1, except as otherwise provided herein.
What page is it?
I'm in my rules. It is the current rule.
Oh, sorry.
It's also
Yeah.
with.
Oh, it's actually, it is in here. Hold on.
It's
It's
crossed out.
crossed out, but it is in here.
Yeah.
169, line 18.
Right, and,
I still want to get rid of that.
well, and that's where that language is designed to set up the subdivision assignment concepts.
So, I understand what you're saying. Clearly, we've gotten away from that, so we have to figure out the way to get back. And that's what we're here to work on.
Right, well, and I think the idea of figuring out what we agree on, and moving into 205 is a great idea.
Good, let's do it.
That way 209 stands much more clear for the issues it's intended to address.
Okay?
So let's go back to the hypothetical, leaving the particulars of Lorimer Street aside, and 10th Street seems to be kind of an outlier. But if you've got 4 people living there,
Right.
and let's say for the sake of argument, they're covered under the 281.5.
Okay?
They were all there during the window period.
Okay.
Maybe some of them helped build the place, maybe some of them didn't, and the rent goes from one person to the landlord.
Right.
Who do we think? And none of them are married to each other.
Okay.
Uh,
Is there a lease in effect?
Which way would you like to start?
No.
No lease.
I
Okay.
think they're all covered. They're all protected, so.
That's what I was wondering. Is there a limit though? When he says multiple dwellings, like 4, is there a limit to square footage and people in it?
I don't think that we have to be concerned with that. I think if somebody wants to assert that, then let them assert that. I don't know that we don't necessarily have to police that. There are other mechanisms for that to be policed. And when we tried to police it, the court struck us down.
Yeah, that was the Modern Family in
Yeah.
Financial District. Do you remember their street?
It was Thames Street. It was-
Yeah.
I think it was 1315 Thames, I think.
Yeah, in Brooklyn.
Yeah.
Thames Street, Brooklyn. So in my example of the person who did all the work, developed the unit, and struck an agreement with each roommate that they would not make the claim, presumably if some roommate made a claim, both sides would present their arguments and some bright light over an oath would make a recommendation and then it would come to us to decide.
Mm-hmm.
So what we're doing is, if we take a broader view of who's protected, we're running the risk that there will be squabbles amongst the individual occupants
Correct.
that could come to us.
I don't see how they would come to us. I mean, we're going to follow what our rule says. The fact that, you know, if the person who did the build-out entered into this private agreement with a roommate, and the roommate violates that agreement, the remedy for
He's not with
the
us.
tenant that did the build-out is to go to court and say, we had an agreement, I gave you consideration for that agreement, and you can't do this. Jump in if you disagree.
So far, you know.
So,
How do you like this job so far?
That's really interesting.
Yeah, good. Good.
I think what Deputy General Counsel Lynn brought up is interesting from a housing point. If you become the prime lease, let's say there's a single person, they have a lease, they need roommates to survive.
right,
They need 3 or 4 roommates to survive.
okay.
What she described, you can only have 1 roommate. Do we have something, people ask me this all the time, I have no idea how.
The MDL says it could be, there is an MDL definition in it, and it does talk about borders.
I thought it was 2 or 3 max, but I would like to know that.
I think it's 4,
Four
I think
borders.
it's 4.
Unrelated.
Yeah, unrelated.
So
But
is-
does that
is-
include the primary person, or it's separate?
No, it's the primary person plus 4.
Is there a conflict then between the RPO and the
I would
MDO?
have to look at the specific code and the other referring to. That's not a mechanism you can cite to housing court to evict someone.
The definition of family.
You would have to use the RKPL to evict somebody. If you're the landlord, you're trying to evict someone in a residential unit, if you're trying to evict someone for having more people than you think is allowed, the tenant has protection in that you're allowed to have a roommate. So if you're a landlord, you can't evict someone for having a roommate. That's what the RKPL says.
But if they had 3 roommates?
And yes, arguably, the RPPL does not protect you for having 3 roommates. That's against what the legal protection is offered. Because if you can't do it, the way they'll let you, but the legislature does not protect you from that.
It's in definitions,
It's the
right?
definitions,
It's
yeah.
it's
It's
what-
the
the
definition of
definition of the
family
MDL.
in the MDL.
Yeah, right. And again, the MDL is separate from the RPPL. Like, I have not seen a landlord try to evict someone based on the definition of an MDL. I don't know if they can. I don't think they can. There's case law that says that only city agencies can enforce the MDL. And I've never seen a landlord try to do that.
It's the
RPPL.
RPPL. Okay, I had them.
I think it's 235F.
So
check
Helene,
that.
wouldn't
I
it
got it.
speak more to the coverage of the unit than the coverage of the, or the, if you're referring to a definition, no, maybe not. So isn't it, where it's in the MDL, it's,
Here, I can read it to you, I have it, okay? A family is either a person occupying a dwelling and maintaining a household with not more than 4 boarders, roomers, or lodgers, or 2 or more persons occupying a dwelling, living together and maintaining a common household with not more than 4 boarders, roomers, or lodgers. boarder, roomer, or lodger residing with a family shall mean a person living within a household who pays a consideration for such residence and does not occupy, such space within the household as an incident of employment therein. Okay, so that's what a boarder, roomer, or lodger is, and that's the definition of family in the MDL, and that's what we're talking about.
But but where that is in the rules of the MDL has to do with what the definition of multiple dwelling is. So a dwelling contains a family.
Correct.
And so in order to have multiple dwelling, you 3 or more units,
You need
each
3 or more
containing
families.
one family,
Mhm.
and then it takes you to the definition of what a family is and then what not a family. So it could be used almost for both discussions or both arguments, because similarly, in order to have a unit, it needs to have a family.
Yes, but we're not, that's not the rule that we're talking about.
Yes, I know.
That's what
We're not talking about
Yeah.
coverage of units, but it just usually when, at least when we would not, use that definition, it's not about who, because there's nobody, right, when you're creating a multiple dwelling, say as an
Right.
architect, right?
Right, there's nobody.
It's how you're laying out the idea of the rule of the law is like, how do you create an apartment for filing with the DOB or with the state? So it, how are the bedrooms laid out?
Right,
shared kitchen,
right, light and air and all of that.
all this kind of stuff, right? So it doesn't really take into consideration at that stage who is in all those bedrooms.
Right, but that's why the loft law is grafted onto that, right? So that's, I think, one of the reasons that it was placed in the multiple dwelling law. But we need to deal with, again, the legislature did not define occupant qualified for protection. They left it to the loft board to make those determinations through rulemaking. We have a rule that doesn't appear to be working for a lot of people. We want to change that rule, so we have to change it. So,
Sounds like we're
pretty good.
moving collectively in a direction that protects more people and that we are more or less in agreement.
So I have this language, right, with the exception of number 2 on page 172, on line 2. I have this language, which I think codified what the board wanted.
I have one question on 3,
Okay?
which is 3, the concept of 3 and breaking the coverage application, the protected occupant application into separate applications, as some of you have heard me say many times, was created by the board staff around 2014, without any public hearings, without any discussion. And the reason given was because at that time, there was a window of opportunity for filing for coverage.
Well, we weren't allowed to cover.
Then the window was about to close.
Right.
So we said, oh, well, if the building is already covered, you could still apply as a protected occupant.
Right.
I question why we, at this point in time, now that coverage is open and there's no limit on it, why we keep those applications separate.
Because, let's say you have a unit that's already an IMD and somebody moved out and somebody else moved in, that person can't apply for coverage. The unit's already covered. They have to apply for protected occupancy. Also, I think it's a different standard, right? I mean, the laws are valid, but there are different standards. Coverage, one of the things that we talk about for coverage is that you don't have any kind of you have a residency requirement during the window period, but it doesn't have to be your primary residence, and that's well established. But I think it's different for protected occupancy. If you want to be a protected occupant, you should be there. That I feel very strongly about.
The law's been on the books for 25 years or 30 years that, yes, if you're a protected occupant under the loft law, you have to be using the unit as your primary residence.
Yeah.
Yeah, there's no
Right,
dispute about
right.
that. I guess what I'm questioning is, so now, if anybody wants to, new unit, covered freshly under 2816,
Okay.
and however many people are involved, why do they have to file two separate applications? What's the-
Because there are different legal standards, and you could cover, as we've seen, you could cover a unit and not cover a person. You could cover a unit and not protect a person. We've done that. Because some people that file for coverage don't necessarily qualify for protection because they live in Long Island.
Well, then what happens to that unit? I mean,
Or with their girlfriend.
It's,
These are real cases.
I know.
I figured.
I mean, the protection gets
In
there
my
for
mind,
someone.
it goes with the
I
unit.
guess it gets protected for someone else.
The next person.
the next, whoever leases it, but then the landlord might just keep it empty. I mean,
I mean, I guess that's possible. It's always possible for the landlord to warehouse, I guess.
It just the contract stabilized.
Yeah.
Well,
Well, it becomes
if-
rent stabilized when it's legal. The owner still has to legalize the unit, even if there isn't a protected occupant. It's a covered unit. The owner has to legalize it, and yes, whoever rents it will get a rent stabilized lease.
We did.
We just did that.
We did the case, well, last month, where originally we were just going to have the owner register one occupied unit. Instead, we said you've got to register all four. The other three were subject to 28612 buyouts, we
Right.
determined.
Right.
Therefore, you can rent them residentially at market rent, but once you bring the building up to code, you will have to offer a rent stabilized lease to those three units?
No, you would have
no.
to offer a rent stabilized lease just
Only
for
to
the
the
one.
one tenant, yeah.
Yeah.
You can rent market until it's
If there's a
legalized?
buyout, yes.
Until it's legalized?
Yeah.
And I have a deed.
Yep. As long as there's a buyout.
But originally you could do that if it was abandoned too, but we changed the rules on abandonments.
Well, they have to file for abandoned. They-
Right, they have to bring it up to code before they can go.
Before they can go to market. So are we okay with this language?
With 3 or the entire package?
3 through,
Are we going step by step?
we can go step by step. Are we okay with 3?
I'm okay with 3.
Is everybody else okay with 3?
Right, that's just what we discussed.
You can't be a protected occupant if your unit's not covered. Coverage is a condition.
Okay,
Talking about this three?
yeah.
That's 3, yeah.
4.
On page 172.
Line 4.
Okay, so now on line 8, or I, this is actually just to recodify what we have now, right? If they use the unit on the effective date of the law, they don't need owner consent.
See, but here's a place where we're tracking sublet assignment or subdivision, which in terms of the one big happy unit is not germane.
So we could change this to say if we're moving it to the other section.
Right.
The individual used the unit as a primary residence on the effective date of the law, lack of the consent of the owner or the holder of the owner's interest does not affect the rights of the individual to protection,
Right.
right?
Would that be in conflict with 2 if we broaden 2 the way we discussed? And how many significant others can I have? 1. Really? Where's it say that?
I think that's
it's
the,
domestic or what
The
they said
domestic
that's
relations
something
law.
Yeah.
Oh, okay.
In New York, you can still only have one spouse and one domestic partner. We're not in a state with polygamy.
Well, you have my significant.
I did that research before I got here.
There's probably some of you would be very unhappy that we added spouses, you know.
We already agreed on spouses.
No,
We're not making
I thought that was
spouses.
his way out.
I'm on that side.
Okay, so we'll change that. Okay, we'll take out the to a sublet, assignment, or subdivision establishing such occupancy. Okay, so it'll just read, if the individual used the unit as a primary residence on the effective date of the law, lack of consent of the owner or the holders of the owner's interest does not affect the rights of the individual to protection.
Is the,
So,
here we've got a new term, holder of the owner's interest.
That was Mr. Carver's,
Oh, okay. All right.
that was Mr. Carver's suggestion, because we originally had owner or responsible party, but responsible party didn't quite fit.
So now, just so I'm clear, and I'll try to make this the last time I bring this up, our intent would be to move the amended language into 205.
Correct.
Whereas we will leave this language in 209.
You want to leave it in 209?
Well, in 209, to a sublet assignment or subdivision is part of the whole scheme.
Okay, so,
I thought we were taking out that line about sublet, assignment, or subdivision.
right,
It is relevant
if there is a sublet
if
assignment
you-
or subdivision.
If you isolate the issues of subdivision, subletting, and assignment, and keep that in 209, then it's relevant.
I see.
Mhm.
And if you move the question of the one big happy unit into 205, then it should be stricken, is what I think. Freely with
But do you
photographer.
but do you want, does the board want, I shouldn't say you, does the board want to leave some language to protect people who sublet or assign or subdivide if they don't have owner consent? If the board wants to leave some language in this section about that,
yeah,
then we'll
that's
do
what I
that
was
as
just
well.
gonna ask you is, I'm confused, you talked about who was there the date of the law, and we talked about the person who moves in December. So they missed the date of the law. You said that it's running the unit, and then you need the consent of the owner.
That's the next section, if you moved in after the effective date of the law. Okay, but the question is for this section, right, if you are, let's see, you're somebody who lives there, you have a sublet, the let's assigned the lease to you, you are an occupant of a subdivided space, you were there prior to the effective date of the law, you don't have to, you don't need owner consent to be protected.
And where does it write that?
I don't know that
it's the
we,
date
I
of
don't
the
know that
law?
we necessarily need it. Where does it say the
Where
effective?
does it say where all those circumstances are on the date of the law that she was convicted?
So on line 172, 8, 9, 10, on page 172, 8, 9, 10, 11, the way that it currently reads, right, it includes all of those other things.
But where does it say on June 25th, 28th?
It's a-
No, it says the effective date of the law.
Yeah.
It's the effective date of the law.
Which is.
All right, and the effective date of the law is defined as different things for different window periods.
So
Right.
if we're looking to a broader scope of who's covered,
Right.
does the language in 4 come back to seem to limit it to the individual who you? No, I'm sorry,
No.
I'm sorry, I'm misreading it. Yeah.
No.
No.
4 totally deals with, do you need to have the owner's consent or not? Right? That's what 4 is all about. Right? When does the owner have to say, hey, no, I didn't allow this,
Right.
they shouldn't be protected, right? And I think the import here was, but wait a minute, they were there forever, they were there prior to the law, you let them be there prior to the law, whether or not you knew was a different issue, right? And yeah, they should be protected and you shouldn't be able to kick them out,
But
right?
the day after the law,
So that's why you need
all of a
consent.
sudden the landlord.
Because you didn't, because, look, I mean, the landlords didn't necessarily know that this law was gonna be a law, right? You know, they're just kind of doing things on an ad hoc basis maybe, and so they didn't know, right? But now there's a law, so they have notice. So if you know that there's a law, and even if you don't know, you're supposed to know, right? So lack of knowledge is not a defense if the law is actually in place. So now the law is in place, and you know that the law is there, but you're doing it anyway, well, that person's protected and has some rights. Because you did it anyway, and you knew that there was a
The
law.
day after the law though, when the landlord now can just say, nope, consent to nobody.
Yep.
And then the person who lives there is dependent on roommates to survive. There's.
No. But so the protected occupant can always bring in roommates, That's
Okay.
not the issue, right? The issue
There's
is
no one ever protected unless the owner says it.
for people that came later, right? So somebody was living there in 2015, 2016, and then
I just don't understand why the owner would ever say yes.
they get rent.
Right, and
They get rent.
there could be scenarios where someone's protected occupant and they bring on a roommate to help them defer costs, but they don't want that person to be a permanent roommate. Like, oh, my mother's sick and I need some extra cash flow while I'm taking care
Right,
of
I
her.
get that part.
And
It's like
then,
a
and
roommate
then
for
it ends, and then you, as the unit lessee,
But if you're,
don't want to
imagine you're
extend
like
that.
single and your roommate's left and you can't afford it, you're like bringing your best friends. You're like,
Yeah.
let's do this and be protected occupants. But they moved in after the date and they're like, landlord, can I please have this person? And the landlord's never gonna say yes. They're just gonna let them be a roommate, but they're not gonna.
I think it's hard to say what an individual landlord is going to do in an individual circumstance, but it seems to me, from what I've seen anecdotally in the larger buildings in Brooklyn, and we have one case about this, these landlords are converting these buildings for residential use, and they're giving leases to people. So, we had a case where somebody moved in and wanted to be a protected occupant into a unit that was already covered and wanted to be a protected occupant, and the owner alleged that there had been a sale, and it was a photographer that died, and he said he bought the estate, he bought the estate's rights, and we found no, and she was protected. But the owner got entered into a lease with her. The owner didn't say, I'm not going to give you a lease. The owner entered into a lease. So, they do it. Whether they should, shouldn't, I don't know, I'm not their lawyer, but they do. So.
Yeah, I guess I'm just reminded, this is meant to all die out, like the whole system dies out.
Never.
It's not.
That's
Like,
never gonna happen.
Not perpetual
Yeah.
protection, it's
Yeah.
just like meant to slowly become extinct.
I mean, it would be wonderful if, somebody created really great live workspace that was out there and affordable for everybody and you didn't need the law, but not in my lifetime, I don't think, so.
At least not in New York.
Yeah. Okay, so 4, we'll take out that law, the little piece. I'm not sure that we need it in the subletting section, but we can take a look at that. So 4II, so these are when they move in after, right?
Yeah.
They need landlord consent, so how do we figure out if the landlord consented? So these are factors, and I know Martha always hated factors because they could go one way or the other. They're indefinite, but that's the whole point, right? So did the owner or responsible party accept rent from the occupant? I guess that should be owner or holder of the owner's interest if we're going to be consistent. I like that. And then and I know somebody had raised the question.
Can we just,
probably-
I'm sorry to interrupt, but
Yeah.
couldn't we define owner as the actual owner? Or
No, because the problem is there's an MDL definition of owner, and in a lot of these buildings, there's net lessees, there's all kinds of arrangements.
So we have to say this all the time?
So, yeah, pretty much.
Would it be a managing agent also? Or is that?
It's the same
It
thing.
could be a managing agent, yeah,
But
but a managing agent is a holder of the owner's interest, right?
Right,
Yeah.
no, that's,
It would cover
that's my
managing.
question.
Yeah,
So what,
so I think
so
this,
if you, if a building owner, say a less savvy building owner, engages a less than scrupulous building management company to run its building, it could end up inheriting a lot of these responsibilities that maybe it's unaware that it's inheriting.
I guess that could happen. I would say choose your managing agent carefully.
I know, right, I'm not defending that, I'm just asking as a factual question. So, right.
I think that's certainly a
Buyer
possibility.
beware or something, right?
Yeah.
Okay.
So the owner or the holder of the owner's interest accepted rent, so how much rent do they have to accept? Does one rent check count? Does 5 rent checks count? Does rent for years count? You know, and I know that question was raised, but that's why there are factors. They can go one way or the other, and there's going to have to be a factual determination, right?
From the oath judge.
Yeah. Well, no, from the loft board. We'll get a recommendation from the oath judge, but ultimately it will be the board that decides.
And just for clarification, this is when there's not a lease in effect.
When there is not a lease in effect,
If there was a lease in effect, it would have to be for the lease.
the prime lessee, if it were a prime lessee, yes. If there were a prime lessee who was asserting rights.
If this is meant for no lease purposes, we might have to change rent to use not considered, which is a minor note. It functionally is the same thing.
We could change the definition of rent, or put in a definition of rent if we don't.
Are you saying the owner or
Holder of the owner's interest, we have to change that. to
HOI accepted rent?
From the occupant, right? The holder or the HOI contacted the occupant for access to the unit. Oh, but if they only contact them once, does that count? Again, factual determination, that's why they're factors. The owner or the HOI listed the occupant on loft board filings, I think that counts.
Oh, yeah.
Any other factor that the board deems relevant. It certainly shows that the owner knows that they're there. I guess an owner could say, well, I listed the person on the loft board filing because I have to list every affected party, and I thought this person was an affected party, but I never consented. That could be an issue in a case, but it's just a factor to be considered.
Are we going back to, sorry, I was late.
Sorry, Tina's.
Tina's. Were you commenting on line 17 that it should be accepted rent from the occupant for use and occupancy?
No, sorry, so there's a rent and there's a concept called use and occupancy in housing court, which is that when you don't have an official lease, when you pay money to the landlord, they don't call that rent, they call it use and occupancy. The idea is that rent is tied to a fixed dollar amount in a lease somewhere. So if you don't have a lease, you might still owe use and occupancy, something like that.
So you
But if there was a lease that had expired, then it would be rent.
Yeah, I think so.
Okay. Let's leave it as rent for now, and then if we feel we need to change it, we'll fix it.
What is it in, so if you have a two-family home, and you have a tenant and then the lease expires, but you allow the tenant to stay on a month-by-month basis?
That would still be a tenant, that should still be considered rent, yeah. So that only really covers situations where there's no real landlord-tenant relationship.
Okay. Understood.
Okay, so now we come to 5I. So I just do want to tweak the wording a little bit, because as reading it over, I wasn't happy with it, but it's minor stuff. In addition to the requirements contained above, in paragraphs 1, 2, 3, and 4 of this rule. So I'm just moving
It's
the,
contained in paragraphs 1, 2, 3, and 4 above. It's just the way I've always seen it. Say that again. But she makes more rules than I have seen, so I'm saying in addition to requirements contained in paragraphs 1, 2, 3, or 4 above.
You don't need the above, it says in this.
Well, that's what she's saying. No, this rule is big.
oh yeah, we could get rid of the above altogether. If we just said, in addition to the requirements contained in paragraphs 1, 2, 3, and 4 of this rule, right?
No,
Yeah.
but of this rule is only, what, 2 and 9?
Yeah, or in this
Oh,
rule,
whatever.
Yeah,
in this rule,
right.
of this rule.
We want to make sure that it's only these paragraphs 1, 2, 3, and 4. We don't want any other
Not every
paragraphs.
paragraph.
Right, I mean, the other rules have paragraphs 1, 2, 3, or 4, so we want to make sure that it's just referencing this one, right?
No, we're not moving this.
Well, we are.
Oh, okay.
So I'll have to change, I may have to change the cross-references, yes. If we're moving it, yes, we are moving it, so we'll have to change the cross-references.
So just take out the word above.
Yes. Okay. The loft board may find an individual is a protected occupant only if the individual uses the unit as a primary residence on the filing date of the application for protected occupancy. So this is Chuck's line versus point, this is the point.
This is,
And that's about finding whether the rule, so that that person applying doesn't have to provide years of.
Right. So let me just say that we did have a case last year where we had somebody who moved out and then moved back, but moved back after the date they filed the application for protected occupancy. So that person, we protected them under the current rule, but under this rule, we would not. I feel compelled to point that out.
well, and I know one of the arguments, and I think Hughes is still on appeal, if I'm not mistaken.
I would have to look it
Yeah.
up. I think he may have filed under 2816.
Uh,
It may have been settled.
Wouldn't blame him for doing that.
Yeah,
But the attorney, the original case, said, we didn't know, there was no rule. But so much as I would prefer primary residence only being an issue after you become a protected occupant, this is much better than the indeterminate
right. Time
period stretching out into the prior decades.
Right.
While I still don't like it, and it's also, it makes sense.
Yeah.
Okay, so get your house in order. You know, if you're finishing up your teaching residency in Berkeley, where you had a lease on a house, and come back and then apply, so that even though you might win, you won't have to have that fight.
Right.
Yeah,
Right.
I like this. Makes
Okay.
it less tedious and expensive.
Okay.
Great.
Yay. Okay, and then the next section is determining, how do you determine whether or not somebody uses the unit as a primary residence? So we took some factors from our case law, from housing cases, and the board had worked through some of these already in prior iterations, prior discussions. And so, if there's anything you want to add or change, I think they're pretty straightforward and clear. And again, factors, so they can go one way or the other, and you weigh the totality.
So it's not just any one of these, or 5 of these, or 3 of these?
No,
It could be everything.
it
Or
could be
just
everything, it
one.
could be, yeah, it could be. If it's
For
compelling,
For
yeah.
example, A would just be, you just need that.
Right.
Okay.
Would B, do we need his or her, do we need gender pronouns? Can it be just be whether
Yeah, yeah.
furniture?
Furniture, clothing, or other personal effects, yes.
I think personal effects is enough.
Well, I don't know, you could have a toothbrush and not live there. You could leave your toothbrush there but not live there.
If you brush your teeth once a week.
She's got a point.
I mean, not to get personal, but my kids all have toothbrushes in my house. They don't live with me. I love them, but they don't live with me.
I use magic marker. Put initials on.
Well, there is some effect. Actually, more than toothbrush.
That would be more than a toothbrush. All right,
Shaving brush.
yeah.
I mean, I have a question about that one, B. Clothing's a good one. I mean, you can leave a sweater somewhere, but
Mhm.
I kind of, this one person drives me crazy that's in LA. But he could, like, just like an Airbnb, like furniture, you put generic.
That's why it's in factor.
It's just a-
That's why it's a factor.
And then you're gonna claim that.
In the Hughes case, it was his cat.
Yeah.
He left his cat.
Pretty significant.
That's pretty,
But
yeah.
he wasn't living there. But his cat lived there.
So he had to rent it out for his cat. So, yeah, I mean.
We toyed with that idea. Protecting the cat.
This is, like, for example, A would be inclusive, for
Yeah.
A, but if B was combined with some other stuff.
All right, let's just move on. It's,
Yeah. Right, so whether the individual lists the IMD unit at the address of the individual's child, as the address of the individual's child on school records, we had talked about that in the past. Whether the individual listed the IMD unit as his or her residential, as,
Yeah, I was trying to do that one.
yeah. Individual listed the IMD unit as
It's a
a residential address on official documents with government agencies. Such documents may include but are not limited to blah, 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 blah. Whether the individual subleased the unit to another in violation of the law or the law board's rules, and any other factor.
Isn't there another form of registration beyond voter registration and driver's license that the city gives to
Well, it
people?
says, yeah, well, there's a non-driver's ID or whatever, but
Yeah,
It just says
it
such
says
as.
such as, right? Limited, but,
Passport.
okay,
right.
all right.
John, there's something wrong with the sentence on C. I think it's
C?
something floating.
Whether the
For the
individual
individual
is-
is the IMD unit as the address of the individual's child, if any, on the child's school records.
I'm wondering about C.
There's something, no? List the IMD unit as the address of record
For the child,
of the individual's child.
If any.
Oh,
if they have children on their
on-
school records. In other words, let's say, you have a child registered in school, and what address is listed as the child's official address?
Right.
Now, you could theoretically have divorced parents, and one has the official address on the school records, and you're the IMD tenant that's living elsewhere, but that's still your child.
okay.
That's why it's a factor.
Well, maybe.
That's why I was wondering on C. I could imagine if Martha Cruz was saying it can be used for or against you.
Yeah,
I could imagine where someone could research and find a family where they list another address, because I'm not condoning it, but.
they
a
want
lot
their
of
kids to
people
go to the
cheat.
zone school.
Yeah, so they put someone else's address to get their kid in.
That's why it's a factor.
But that's like a crime, but that's nothing to do with our crime.
Well, it is.
Is it crime?
Yeah.
Is it something that's going to be prosecuted? I don't know.
Yes, the child's dress needs to be.
Small potatoes in DOB world, but.
But I wouldn't want it to be like get someone
It's a factor.
a factor, but
A factor, they can
if you
explain
had
it.
like a really mean lawyer, they could like make that the
I
factor.
want to reiterate that the ultimate decision on this
Is support.
is the board's.
Okay.
Well, but Julie's point is, as I was trying to express, particularly when we had a long period of proof of primary residence, there are lawyers who will make outrageous demands for all kinds of documentation. So I agree that where we can avoid ambiguity that will exist just to allow some, really sharp-toothed litigator to possibly force a tenant to fold their hand because they can't afford representation. Let's try to keep it as clear as possible.
So do you want to take this out? I mean, I think housing
Kind of, I don't know
We do
why.
it,
C.
not specifically enumerated, like some things are really important, like D, like that's always a factor, like C,
Yeah.
I've never seen anyone raise that with just on their own, but D, like that's always something that comes up. Like
Yeah.
A, B, and D, it always comes up in no matter circumstance. C does not come up unless there's reason to believe, like the landlord's not gonna ask about your kids unless they know the kids is there. It's not like a standard go-to in housing court. So I do wonder why it's there, maybe we could just take it out. If we know it's a
Yeah, I
factor.
think take it
No,
out,
maybe
because
say-
even to bring kids
well-
into it seems like.
Well, what if, is, like, legitimately, right? I got a temporary assignment to LA, right? I need a job for a year or something, and my child is going to continue school, right? But the landlord claims that I'm not living there, my child.
With like the grandma living there temporarily.
Well,
Yeah.
somebody else,
Could be.
roommate, somebody, so the child's records are in school.
Your spouse.
So I think it's fine. I mean, we're thinking more of the fraud situation, but it doesn't have to be.
Well, wouldn't C be subsumed into D under official documents filed with government agencies? Assuming you're going to a public school.
No.
Except that's
Right,
your
it's only
official
public school.
document.
It's only
not-
public school if you're not going to public school.
Your or your child.
Or we want to just add school records? Or
Yeah.
school records? Go up to D and then take out C?
Well, no, because it wouldn't count if it was private school.
No, school records.
No, but this is official documents filed, D is official documents
Only
filed with
government
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 agencies.
agencies.
Okay. Or school records.
You might as well leave it separate.
I
Do
mean,
you want to take it out? We can
I would
take
like
it
to leave
out.
it there. I would just like take out if any because it's irrelevant, if it was just child.
If they have children, if they don't have children.
No.
They don't
That's
have,
kind- they don't have children.
obviously,
It's
it's
like-
a
Okay.
school record,
They
right?
can take out if any.
If any, yeah.
I do think it might otherwise invite an owner who has not thought of investigating, asking for child records to ask for child records. Like, I think it does create.
Oh, you mean it creates that? No, but this is just, no, these are just factors, right? That's
You're
what
just
I'm
not
saying.
right, but if you're like an attorney coming into a case defending.
Where's your
your
child's
client-
records?
Right. and
Right, they
might
could ask for it in this
You can
guy.
say, it's none of your business, I have the other ones.
You could, yeah, the attorney's attorney.
Well, no, I mean, the oath could actually issue a subpoena for those documents. But again, you're only proving it on the day of the application, right? It's not for a long period of time anymore, so I think it's okay. But if it's gonna be controversial, let's just take it out, because I wanna finish this.
Yeah. All right, I think two of us are thinking take it out. I'm wondering for those who want to keep it in, why.
I'm fine with taking it out.
Oh, I think it should,
Mr. Rubin.
it should stay in.
I mean, I think that if ever came up, the tenant would provide all
Okay.
kinds of.
I tell you what,
But I think a sharp lawyer is gonna do what a sharp lawyer does.
let's include it in,
Resist the-
and any other factors the board deems irrelevant.
Well, actually, I think that line
Relevant,
is
not
redundant.
irrelevant.
No, irrelevant.
It's
It's not necessary.
redundant because it says in the first, as a primary residence include but are not limited to.
Yeah.
Mhm.
I mean, if
And then
they're-
you have the F there,
But
right
you
there.
don't need the F because it says in the opening paragraph.
But not-
substantial-
Yeah, I always like to throw it in though.
Substantial
Cover
number
your
of
bases,
kids
you
don't
know.
go to school.
Okay.
I'm sorry, what, Mr.
A
Barrow?
substantial number of kids do not go to school.
They don't go to school at all?
Yeah,
about
I mean,
vaccination?
the parent could sort of, you know.
Oh, homeschool. Oh, that's okay.
So how do you
But don't they
prove
have
that?
I think they have to register them if they're homeschooled.
Yes, you have to be homeschooled.
You still have to
which
register
would
your
mean that
child.
you live in
It's
there.
Maybe so.
Yeah.
All right.
For sure.
The rules differ.
Okay, we're taking out C.
Well, I think in New York though, you have to
Yeah, yeah,
register.
yeah.
We're taking out C.
We're taking out C or,
We're taking
no,
out-
we're leaving
oh,
it in.
You saying, well, you're for taking
I
it?
said I'm fine
With what?
taking it out.
Yeah, I thought that's what
So
it
we're
said.
taking it out?
Yeah,
Why?
the other things.
You're
Actually,
doing
it should
number-
stay in.
Yeah, I would take that.
We're outnumbered, and we don't have enough.
You guys, what do you want?
No, let's take it out, let's move on.
Okay.
That's good. Is any other factors? It's F covers it, which would be now E, right? I guess we're
One
gonna.
Yeah, we-
small semantic point.
Yes.
the term of, it's actually a driver license. It's not a driver's license.
Okay,
That is true.
okay.
I wonder, when did that change?
No, it's always been,
It's
it's
a
so
common-
true.
Really?
Yeah, the only reason I know this is an interest in government agencies that have the power to revoke driver's license already. It's not a driver's license.
Okay.
Driver license.
You don't
That's
want to check
fine.
that, Mr.
It says actually on your, you can look.
It does say on
It-
it?
I believe it says on your driver's
Driver
license.
license.
But it is a
Driver
driver
license.
license.
Well, it's your driver's license.
Yes.
It says driver license.
Says driver license.
That is, on the record, it says driver license.
Mine says,
Okay, okay,
Yeah.
may not be.
mine says drivers for the population.
It
Does
does
it really?
not.
No, does it really?
Well, I don't have a car in New York City, so I can name.
Oh!
Okay, let's not go there.
Have a main
Let's not
driver's
go there.
license.
Let's not go there.
Well, having a main driver license is not going to help you in this particular service.
Yeah.
That is right,
Sure.
very good.
Yeah.
Okay, so we'll renumber that. All right, so,
And then that's also,
moving on, so we're gonna take this language, okay, so that goes back to number 2. We're leaving in, we're gonna draft language to say that the prime lessee with the lease in effect is the prime lessee spouse, domestic partner with a lease in effect are the protected occupants to the exclusion, right? The board agreed to that?
oh, sorry.
Prime lessee with lease in effect and spouse
Right,
or
domestic partner.
domestic partner.
This is 6?
No, this is number 2 on page 172.
Oh,
We sort of never resolved it, including, all right, so a prime lessee and their spouse or domestic partner with a lease in effect is the protected occupant to the exclusion of everyone else.
If applicable.
Well, I don't think you really need the if applicable,
Yeah,
because
so-
they have the lease in effect,
Right,
so I don't
right.
think you need that.
Okay, so period
That's
after
the whole
else.
point of the sentence, right? That
Right.
it makes it is
So,
right.
so the consequence of this is we're letting spouses and domestic partners sneak in under the tent. But we're saying if I had a long-term roommate who's not on the lease, if the lease is in effect, that person is not protected.
Yep. You might want to become domestic partner.
But it's not sneaking them under the tent, they should have been able to walk in the door.
Thank you.
I
Yeah.
don't know why. It was like,
Well, we've had a half a dozen that we slammed the door on is why.
Okey doke?
So, okay. But
But,
what,
by the way, that may be the reason why the person is not a, because the lessee did not want that, right? So we don't enforce that.
not her. So who are we, who's this language, what are we,
The person is least in
by
effect.
expanding it, we've addressed my issue of splitting spouses apart, and or domestic partners. But now, who are we, what is the purpose of having this?
Of having this section,
Number 2, yeah.
because there's a contract,
Okay, all right,
right? So it's because the lease is in effect, that's
Okay.
why,
all right.
right? And the prime lessee has rights under that lease.
Whereas if the lease, and it's with the lease in effect,
means it's
when?
current, it's not old. When you say in effect, it means,
On the date of the application,
Is that,
that's the date that we used below,
yeah.
on the filing date of the application for protected occupancy.
If you,
Everybody will wait until their lease is expired to file.
yeah.
Or or they'll run in because they don't want their roommates to be protected, that's the flip side.
Well, as long as we make it clear.
Yeah, okay, so why don't we just mirror the language below, right? A lease in effect on the filing date of the application for protected occupancy, that's how we said it in 5.
In general, most people have an expired lease. So all those spouses and.
Right, but then it's
If the lease is expired, then it could be everybody.
So they're de
It's more protection.
facto,
It's
right?
more-
But then, is it not, or I thought Carver always argues that an expired lease is the exact same power as a current lease.
That is his argument, and there is some merit to that argument, but I think the board can take a chance and see what happens if we get a challenge.
What does the law say about adding people to your lease?
You have to do with the landlord's consent in general, unless in an event stabilized lease, you can add your spouse as a right.
At the expiration.
At the
and- and
expiration.
new lease.
Yes.
And so with the roommate clause that we were talking about earlier, can, obviously, there can be an agreement to amend a lease to do anything as long as both parties agree, right? Is there any way to force a building owner to accept?
Now, well, you can't force the owner to add a roommate to a lease, no.
But you could marry your roommate,
Yes.
in which case the owner would be legally obligated.
In which they would get a roommate, they become.
Right.
Yes.
Or marry or,
Or, does it include domestic partnerships?
No, but I don't even know if we do domestic partnerships anymore.
I think it still exists. I don't know, I think,
In any event, no, the residential code does not cover domestic partners, which is only spouses.
Yeah, you still have to file with the domestic.
yeah. But I do think the mechanism still exists. It's probably not used as much now.
That's under
The same-sex
regs.
marriage, same-sex
It's
marriage.
a residential law.
So domestic partner would be out of luck if the partner had died or moved out, is that correct?
Under the residential law, yes, under the way it used to be, but now they can get married, so.
But if they're not married?
But they could
Yes.
still be, they could still argue that they were family though, right?
Yes, there's that. So you can't force the landlord to add you to the lease, but you can.
They would have
success to the lease.
succession.
Succession
Yeah.
rights, yes, exactly.
I guess I'm confused. Is domestic partner the same as common law? No. Where
No,
you-
domestic partner, to be a domestic partner, you have to actually file documents. And it's because it affects
healthcare,
healthcare and stuff
pensions,
like that.
all that stuff.
Well, forgive me for showing my ignorance on this, but domestic partner was originally a term of art prior to the
Same-sex
state
marriage,
adopting
yes.
marriage equality.
Exactly.
Correct.
But does domestic partner still exist?
I think it does, yes.
Okay. We should probably take a look at that, just to,
Okay, but I do think it still exists.
then we can go back to significant.
Yeah, I'm pretty sure it still exists, because I looked into that before getting married.
Okay.
But that was some years ago. But-
We will check to see that it still exists.
I have one-
If it does, we will include it, and if it does not, we will not.
I have one slightly off-topic question, because my guess is at 4:30, we're all going to be so crazed, we're going
No,
to buzz out of
we
here.
stay here to five.
You distributed,
Yeah, that's the redraft of the stuff we worked on last time.
so this, for 210 and 211, this is an update
Mm-hmm, yeah.
that supersedes what's in
Yeah.
here.
mm-hmm.
And now to make my question relevant, will you do the same for 209,
Mhm.
assuming we get through it today?
Sure.
Which, although now it'll be 205.
Yes.
And 209.
Yeah, well, we still have a couple of things to go over in the current 209, but yes.
I'm highly optimistic we're going to go through.
Yeah, we really do.
I have a good feeling.
Guys, let's all pledge
So let's keep going.
let's all pledge to do what, yeah, before we take a bathroom break, I'm going to be like President Pro Tem here. So, let's pledge to get through this.
You're better than the president.
Let's pledge to get through this today. We really need to get this rule going.
Yeah.
Finished.
It's going to come
Almost
back,
finished.
it's going to
We're
come back
almost
to you.
finished
and-
2 pages in 2 hours. others.
Right.
But these are important pages, and the rest is mostly ministerial. No, the rest is mostly ministerial, there are still a couple of issues.
All right, so now we deserve a bathroom break.
Okay.
We
just
adjourn, adjourn temporarily.
Intermission.
Recess.
Recess.
Thanks.
Okay, so we're gonna have to change the definitions in 209A. And I suggest moving them to the front altogether, just to the definition section, because currently, this one we have to discuss, but there's the prime lessee, and we'll get to that in a minute. Privity and tenant, those are also definitions that are in 209A, so I think we should move those definitions to the front if we're moving this section to 205.
Yes.
Okay, so we will do that as well. Okay, so on page 173 at line 19, so this is going to be the start of the new, what will remain 209. Actually, we could leave it here. We could leave them here. We could just leave them right here. Well, we could put them in the front also, but we could leave them here too. So, the loft board may find a prime lessee, or I guess it should be a sublessor, either of whom does not residentially occupy a covered unit, to be a protected occupant only if the individual proves that such unit is a primary residence, is the individual's primary residence. If the individual fails to prove such unit is a primary residence, any such rights of the individual to recover the unit are extinguished. So I think we can go back to calling this section privity, subletting, and recovery of subdivided unit, which is what it used to be called. So I think we could do that. Yeah. The loft board may find a prime lessee or a sublessor, either of whom does not residentially occupy a covered unit, to be a protected occupant, only if the individual proves that such unit is the individual's primary residence.
Well, how can it be their primary residence if they don't residentially occupy the unit?
Because they're in Michigan teaching,
Ah,
right? And they have legally sublet their unit,
I
right?
get it. Right, I'm bringing it back. Got it.
Okay. If the individual fails to prove that such unit is a primary residence, any rights of such individual to recover the unit are extinguished.
Got it.
Why is only in there? Is that necessary?
Yeah. It makes it a legal condition.
Okay.
Okay, so moving on. On page 174, this has to do with when prime lessee can recover sublet space. So, let me see. Prime lessee must exercise and import the right to recover, yeah. So we're adding the date for 281-6. Same thing on page 175. Nothing on 176 or 177. 178.
Except, sorry, going back, on both lines 20.
What page?
173, 126, lines, just all the his and hers, and we want to go through the whole thing and put in individuals or an or is or there everywhere. Just wanted to do that.
Exercise. Yeah. Yeah, okay, we'll change those.
Yeah, just a few random here and there.
Okay, let me just make a note of that.
It's also on 175, line 12.
So that's how it reads now. I can change it. Yeah, that's how it reads now. Because that's not underlined, so, but we can change it. We have to change the number at the beginning anyway. Oh, actually, all the numbering is gonna change.
Oh, no, right.
Yeah, all the numbering is gonna change. Okay. So, I don't have anything until page 181.
Can I ask about 175, line 12 to 16?
12 to 16?
Yeah.
So that deals with subdivision.
Portion of the space.
Mm-hmm. So where you have a prime lessee who subdivided, right, so they leased the whole floor and then they subdivided it into 3 units. This says that they're only qualified for protection in the unit that they're actually living in.
Living,
get
but
to
then
be-
it goes on to say home occupation or joint living working quarters, so they just
Yeah.
mean if there's like some shared, like workspace down the hall, they might not be entitled to it, or is that?
No, this is, let's say you're the prime lessee, you made 3 units, A, B, and C, you live in A, and in A, you have a dance studio and you live there, right? So you get to be the protected occupant of both your residential space and your home occupation or working portion.
But you lose the right to the other.
You lose B and C,
Yeah, okay.
right? Because you're not living in B and C.
If you were working in BNC.
Well then, is anybody living there?
That's a good question.
I don't know.
Got it.
I guess
Yeah,
I'll know.
okay, okay, point taken.
I mean, if other people are living there, I think that you work there doesn't matter, right? Okay,
Well, what would happen if, 3, take dance space, 3
Right.
dancers.
right,
They want to start their own school.
right,
They create a dance studio.
right,
There's 3 little apartments across the back.
right.
So who gets the dance studio?
That's a good question. So the board has gone a couple of ways in that situation where I think that there would be 3 of them. The board might just say that it's commercial space and they each get to keep their unit. And then the dance studio itself is a separate commercial space. But we have had recently, as a matter of fact, I think we had where we had like part of a studio that was part, you had to walk through the commercial space to get to the residential space, and we covered the whole thing. So I can't answer the question. We would have to consider whatever the proof is going to be in the case.
Okay.
Okay? All right, so,
I got
way late.
caught, yeah, that's a good
Stuff
point
for
for
that
it.
one.
Almost. Just on 174, line 11,
Line 11.
Yeah.
That exists.
Yeah.
Right.
pursuant to chapter 135 or 147, it strikes me it should be and,
Okay.
because 135 was all the covered stuff, and then 147 was all the exclusion
Exclusion stuff, yeah.
So You couldn't be covered under 147, you could only be uncovered under 147, so I think it should be in.
Okay, we will change that. Now I've lost where we are. Okay, so we were further down the road, right? We were at 181. Lease between prime lessee and landlord no longer in effect. Prime lessee wants to recover subdivided portion. So this is a date when they would have to do that by, and that date will be 60 days after the effective date of this amended rule, blah, blah, blah. Okay, so again, just adding that to cover the 281.5 and 281.6 units that are covered by the 2019 amendments.
So, wow, we're still in A, B, C,
We're still in the whole subdividing, subletting.
but we're in the subsection of line 23 on 180, and just,
Mm-hmm.
right, line
Yep.
23 of 180
Yep.
is the beginning of the section.
Yes.
Lease between prime lessee, and landlord, no, that's what you just read.
Mm-hmm.
No longer in effect in prime lessee.
Wants to recover the subdivided portion. So here you have A, B, and C, right?
Yep.
Prime lessee's living in A,
Yep.
and the person that was living in B moves out, and the prime lessee says, I want A and B. And they have to do that within a certain amount of time. Oh, actually, even if they're still there, they can move to recover this space. Okay? All right. Similar thing on page 182, similar addition. This is for factors to consider when the prime lessee seeks to recover the subdivided space. And then going forward on 183, for a couple of iterations, we have the interim rent guidelines. So we had to add interim rent guidelines for 281.6, and we did that. The board already approved that as section 2-06.3. So we added all of the references to 2-06.3 where it needed to be. And that's pretty much the same through 187, where again, this deals with the effective.
It's not just 2-06.3, you're saying, but it's more than just, or 1 or 2.
Well, 06, no, those are underlined because they're links.
Oh, okay.
They're not new. Okay?
If it's blue and
If it's blue,
underlined,
it's underlined, it's a link, okay? It's only the black stuff that's underlined,
Okay,
that's new.
okay. Sorry.
I'm gonna have to change that before I send it to the law department. Okay, so same thing on 184 and 185. On 186, again, we have that 60 days after the effective date of the amended rule for the effective date of rent adjustments. And similar concept on line 19 on 187.
Okay.
60 days after the effective date of the rule. We don't know when that is. Yes, this
Where
rule.
it goes through this whole process.
Uh-huh.
And then,
Right.
so you're gonna get a bunch of applicants maybe within 60 days.
We may. Okay. Same thing on 188, right? For an IMD covered under 281.5 that became subject to Article 7C, Chapter 41, or 281.6. This is a limit to right to compensation. Again, this is dealing with that whole concept, as Mr. Delaney was talking about, of subletting, subdividing.
Can I ask
Et
you a
cetera.
question about that
Yes.
60-day thing? Are there going to be trainings or educational, like, people will understand? 60
Well,
days
we're
is
actually
2
going to put in the
months,
date.
that's
We're going to insert the actual
Okay.
date. It's
But
just that we
then
don't
even
know
for
what that
them-
will be yet.
Right. Even for them to be aware that it's in there and they only have 2 months to act on
Right.
something. How do you get that information to the public?
I think that's a good question, and we need to decide that. We need to do outreach now, or to have somebody do outreach.
Didn't we, wasn't there a draft in the DOB was working on, kind of a tenants' rights briefing document?
Brochure.
Yeah.
They were moving forward with it. We had a meeting about it.
That Alex Merchant.
No, no.
That's
Yeah, we had one meeting after, I just don't know where it is right now.
Oh, IGA was.
Yeah. I have to follow up and find out where they're at with it.
And to a certain extent, Julie, I think the answer is that that's kind of on the tenant community too, to get the word out.
Right.
Well, landlords too, right? If someone has this, or landlords too. Do, like landlords can
Oh,
Registered.
you mean in that information brochure, we should also be putting stuff of, well, the brochure.
Well,
should
if
I
there's
think-
something that affects landlords and so on.
Well, now that we're talking about particularly subdivided space, it's going to affect landlords, because all of a sudden, you're going to have more, you're going to be privy with
More people.
More people.
Right. So, yes, I think that we do need to do outreach. Let's get the rules into a, more finalized form, and then we can start working on what the outreach should look like. Okay, so that, I think, brings us to the end of 209 and to our open issues. No, we're not quite done. We're close. We're not quite done. All right, page 4. Well, these are the open issues that I sent you.
Let's start over.
And there's a fresh copy,
Huh?
and you provided fresh copies today of the open issues.
Yes, yes. But this is what I mailed you, right after
Yeah,
this meeting, yeah.
Does our big audience have this?
No.
No, they don't.
Do you have any of these?
Sorry.
Okay. Page 4, line 26 to 27. Some of these are not actually open issues, they are just things that I added and I wanted you to know, because
Yes.
I believe in transparency, and I think I should tell you. So on page 4, line 26 and 27, I added the date, June 25th, 2019, for units covered pursuant to 2816.
You have one extra one up here if anyone wants
I don't
one.
know if they have the rest of the book, so I don't know that that would be very helpful. but they
Oh, I
can
have
it
it
if they want.
What are you guys doing out there?
We're listening.
Okay, so we're good on page 4?
Yes.
Okay. So page 7 to 8, we have the definition of the prime lessee, so I think this is going to change now, based on our discussion now. Prime lessee, unless otherwise provided, means the party with whom the owner entered into a lease or rental agreement for use and occupancy of a portion of an IMD, which is being used residentially while the lease is in effect.
So an IMD can be used non-residential?
I don't know, I think that's the way it read before. rental agreement for use and occupancy. Isn't that interesting?
Yeah, it's,
An oxymoron,
it's a little bit weird, but yeah.
combination?
Yeah.
Okay,
All right.
all right.
And
so
then
item-
striking out everything after the comma?
No, after the comma, which is being used residentially, comma, this is line 1 on page 8. While the lease, it's a spelling error there, is currently in effect. We could just say while the lease is in effect.
So regardless is, not
It's
regardless.
striking out regardless of whether and putting in while.
Wow.
So they're first determined to be in an IMD and then.
Yes, yes. It's always coverage,
But
then
it's all,
protection.
it could all be at the same.
Yes, it can
time.
be in the same proceeding, but two
Yeah.
different applications. Okay?
So the implication that is, once the lease expires, I'm no longer a prime lessee.
I think you're a former prime lessee.
If you only have to be a, this is the line discussion.
No.
I'm not, I don't, I'm just asking a question, I don't have a point here.
I think for the purpose of the loft floors rules, you're no longer a prime lessee. I would say yes to that question.
Oh, well, that was what we actually just discussed.
So then.
Yes, that's what, that's
Yeah,
what the definition, yes.
So, but in essence, we're not, you know what, I'm sure we'll get a chance to hear some opinions about this at the public hearing.
I'm sure we will,
Yeah.
yes.
Okay, all right.
And we can change it. It changes.
Yes, we can. All right, so I think we can add the definitions of privity and tenant in their respective places. We'll carry them over from what was 209A, which is going to change. So we'll carry those over here.
Wait a minute, so you're saying after, on page 8, going in alphabetical order?
It would be after private delivery service would be privity. And then on page 9, after sublessor would be tenant.
And what exactly,
So we're adding definitions in there?
Well, we're taking the definitions from 209 and moving them here.
Yes.
209A,
Okay.
because it's coming out of 209 and going into 205.
Yep.
So it's the definitions go into that, which makes sense.
yeah. What, can you just, again, I'm sorry, I got
What they are?
caught, I got lobbied, I was being lobbied.
Okay,
Can you just reference me the page?
for,
And
so it's not in here, because this only has proposed changes. So it's 209A. Tenant refers directly or implicitly to a residential tenant and is deemed interchangeable with the word occupant in Article 7C and these rules. You want to see it?
Let me just read it again.
Sure. Tenant refers directly or implicitly to a residential tenant and is deemed interchangeable with the word occupant in Article 7C and these rules.
Do you want to say Article 7C of what?
No,
And
everybody should know what it is.
I would hope, but just.
and give me the language, the site.
Oh, it's 209A.
2-0, parentheses,
Yeah. Mhm.
little a, okay.
Little a. Okay. All right, so then on the sheet I have page 13, but I think it's page 14. I think that was a typo on my part.
Yeah.
Yeah, page 14, lines 25 to 29. So this was an issue we had left open, that representatives of the special interest groups may, in their absence, designate a substitute to participate in the discussions. And the substitutes may participate to the extent permitted by the board, and they don't have a right to vote. So were we going to leave that or take that out?
As the only special interest member present today, I posed this question to some tenants, and the general consensus was they would prefer it stay in.
Okay.
The thinking being,
Yeah, go ahead.
the thinking being that it, for whether it's, I'll give you an example. I missed a law board meeting that I knew I was going to miss because I was going to be laid over in Hawaii on the way back from the Philippines.
Right.
So, had that been the case, or if I suffered the kind of, couple months incapacitation that Elliot did this summer, the tenant said, well, we
Still
would
want
want
a
to
voice.
have a voice to represent our position.
I'm fine with leaving it in. I wanted to
Yeah,
ask
and
you.
I think, we all had kind of an odd taste in our mouth over the way that things went down. Gee, it was just this past summer, wasn't it?
Yes.
A year and a half ago.
I had more than an odd taste, that was awful. I never want to experience something like that
And let's take it
again.
out.
So I would say take it out or have the reps, they can't talk, but they can sit here, so they're.
Oh, no, then there's no purpose.
But think about this. I would not suggest Michael Kozak or Margaret Sandercock because of the obvious conflict of interest. The reason that we had such an unpleasant experience, and I could use stronger language as well, was because it was
A member of the board.
yeah, it was a
Well, not just the bar,
yeah,
The owner bar.
the owner bar.
Yeah.
the pit
Well,
bull
he's the
bar.
owner's rep, it's the owner's rep.
But now, for example, we have a couple of owners who seem to attend meetings regularly, and if the landlord, if the owner's representative had designated a building owner, we might have taken a different stance.
I guess I would ask everyone to consider, I can understand they're here and they're present and they're taking notes to keep up on what's happening. They're not allowed to vote. So giving them the floor when they haven't had a background check or anything, I just question it, because the way it played out was.
But then they
Why?
can sit in the
It's
audience
because
and do that.
They can do that in the audience, except that you can't, they wouldn't
They
be able to
can't
speak. So you wouldn't have the benefit of their opinion. I mean, I wanted
Well, they
out.
would have the benefit of sitting up here and not participating, but they would have the documents, they could take good notes to give to a rep like Chuck, to keep that person
But the
up to
benefit
date.
to having them up here, and I'm with you, I wanted out, but I'm saying, for the benefit to having them up here would be, so they can actually hear them, they speak, they could comment and make, and say
And
something,
that
whereas
is
down there, and they're not able to participate in saying anything, so
They
why
could
take,
have- I mean, there's one point, they could have a voice sitting here if we're discussing something. The other point would be like if a rep was sick or traveling a lot, like Hernandez, that they would, the manufacturing industry in that case would be able to have an update, meeting notes and clear, like, I was not only present, I was sitting there, I had the document.
Yeah.
They would have a more inside
the only reason I would,
meeting notes,
yeah.
but to use it as a pulpit for lobbying, and I just didn't, I thought that was.
Yeah, so let me ask the board, because I mean, the whole thing kind of made me think twice also, just like you. So I don't believe this was meant for a one-time thing, like, I'm going to be out this week.
you know, because there's nothing really that urgent for the board that board can't make a decision without, you know,
If a
interest.
person was gonna be out for a week, to your point, Mr. Chairman, they could respectfully ask that something be held over.
Yes, exactly.
I think that I agree with
Right.
where you're going with this.
And so if it's going to be an extended period of time, that is not even, I don't believe, the board member's prerogative. If you're going to be out for a period of time, the mayor's office who appointed you should think, you know, should be given the opportunity to replace you or to temporarily do something. They can, I think the mayor's office can actually appoint.
Yeah, that's
I guess
my point.
they
If
could.
you're gonna be absent.
There's not much temporarily do something they
4
can
months.
do.
But to put someone, say you're going to be out for a month. Next month, something urgent's coming down, something, not urgent, but something of interest, like, you know, you could ask that can be laid over, or send your opinion in, or, you know, have you make your voice be heard. If it's going to be an extended period of time, then A, you should really have that discussion with the chair who would relay whether or not that extended period of time is going to be beneficial to the board, or you should step aside, or have you temporarily be replaced by the mayor's office of appointments, I think.
Except it takes so long.
No, it doesn't, it takes a long time for a permanent appointment, but they can step in on temporary stuff and appoint someone.
Is that, I did not know, is that the case?
Well, the reason why it takes so
Yeah,
long is because they vet, right? I mean,
Yeah.
in terms of, for a temporary appointment, temporary thing, it can be a quick vetting process, because it's not going to be
That's
much.
huge.
So I just don't think we should go down this road again with this. And I'm not speaking officially like from anywhere, like nobody's told me this, but it's just from my own experience, but with this whole thing. But even if we're going to leave this in, we should put some restrictions on this. Like, but I'm not saying it would be what Julie's saying, not speak. But it could be something like that they couldn't be certain, you know, practicing and, you know, certain restrictions. We just have to think about some restrictions. It couldn't be that you're in business, I don't know,
I think that would be very difficult
to do.
to craft.
So
I
then-
think the reason that it was left that the board could decide whether or not to submit to sit the person and decide how much they can do. I think the reason that it was left that way was to give the board that leeway without actually saying it.
So,
And I think it would be very hard to distinguish between groups of people.
okay,
And I don't want to do that.
Okay.
I don't know if it would survive a challenge.
right. No, but it would go for both ways. But here,
That
Do it.
position, is there anything in the rules where those special interest group positions have to be filled? Like, there wouldn't be the fear that if someone's looking at being out for 6 months and it's an important 6 months, they could decide to retire or
Yeah, it's like a
switch.
shadow substitute.
And they would be replaced, it wouldn't be ignored by our mayor's
Right.
office. Like, it would be a priority, right? To replace them.
Well, you know, speaking practically, the manufacturer's seat was empty for maybe 8 years.
Long time, yeah.
And at first, after the first owner representative for whom this was crafted stepped down, initially there was a period where the board took the position that we didn't want to do controversial cases
While the owner's was out.
without the owner's seat being filled. Now, obviously, having somebody sitting in for the owner or the tenant or the special interest who can't vote doesn't completely address that issue, but it's a tricky question. You know, it was It was written to accommodate the owner representative who had an ailing sister in Australia. So travel was going to take some time.
Right.
And the board was in the midst of writing the rules of the whole game. But when we had our experience this summer, the new Chapter 41 was hanging fire in Albany. It was kind of another crucial moment, and to have somebody come in who did feel it was an opportunity to kind of use it as a pulpit was, I understand why people have misgivings.
So what do you want to do?
I want to take it out. If I could, you know, if I distract my pen to take it out, I would just take it out. I don't think in a modern era where we have, you know, no shortage of ways to communicate, and I don't think this is so necessary.
That's a good point.
Yeah, I'm wondering, okay, everyone, you didn't like the sound of someone could sit here but not
I think that's,
take the
I
pulpit.
think it's
or-
no different from them sitting there.
But if they're sitting there, couldn't they report to,
No, but there's no
There's no
difference.
point, there's no point for them to sit up here or sit down there if they're not going to speak.
Yeah.
so if they were sitting there, they could report to the tenant rep who's out for a month.
Yeah.
They could report to the real estate rep who's out for a month. And then
Right.
that person could then take action, write to you, send a letter to all of
Yeah.
us.
Yeah,
There's
but you
action
have, now
they
you
can
have
take.
minutes and you have tapes of meetings.
Yeah.
There's action
No,
they
no
can
point to
take.
that.
Yeah, excellent minutes, by the way.
Yeah, very detailed minutes, so that person could still perform their job if they were in
That's why
Australia.
that's why I'm
dealing
thinking
with
this is obsolete.
They wouldn't be present voting, but they could still have an opinion
Well,
that we would hear.
Maybe,
Well, you said that you wouldn't want to hear it.
Well, I want to hear it from the rep, I don't want to hear from.
Oh, you mean for the next time, but you could always do that without having them come up. They could listen to the minutes and talk the next time. Or listen to video and have their opinion.
I guess I'm saying that, there's ways for that special interest person to stay, if they care
Connected.
about their job, they're gonna stay connected and in touch with what's going on.
Right, but you're saying, you mean instantly?
I would rather have the clause out
Yeah.
if people don't like the idea that someone's sitting here. I mean, I think it has a presence, like if someone's missing, like real estate rep, if there was someone sitting there that was the real estate sit-in, I would still feel like I'm getting real estate landlord representation.
How are you going to
versus
feel that way
them.
when he or she cannot speak?
Because they're looking over us and they're paying attention and they're showing us.
they're
that it's
making
important.
faces.
If somebody's spending their whole day, they're showing it's important to them. Right now, we have no manufacturing industry. I would love to have manufacturing industry every single time, and we don't.
The way I see it, and it's just me wording it a different way than what it's being said, is especially now, when I first came on the loft board, the amount of time we actually had visibility to the cases we were going to vote on was a really short window. And I know Chuck remembers that because I think he and I were both advocates for more time. We're getting the cases now in plenty of time to actually read the cases, digest the information, and somebody could easily forward an email through any one of the board members, but preferably directly to the chair or the general counsel and say, I would like these issues to be discussed at the meeting because I won't be able to be there. So we would be hearing from that person. We just wouldn't be hearing it live. We would be hearing it via what they wrote. And it concerns me. I'm actually surprised that there's not an attendance mandate on this board because it concerns me that, and I have nothing against any of these individuals, but it concerns me that we have lengthy voids in people's attendance, and we don't have that perspective, as
Yeah.
you're saying,
Right,
from
it's great to
that
have
period of
people here.
time.
Always.
And that's not just isolated to the case we had back in the summer where somebody had work issues. That continues to be a bit of an issue and has been an issue on and off. So I would support the chairman if he says he thinks it needs to be taken out of there. I think it's more problematic
Let me ask
than what
this.
it's worth.
It's 15 to 20, was that in the original law
About the quorum?
Yeah, about the quorum and everything.
The quorum, that's governed by state law.
Was
state
it-
law and
I'm
city law.
asking, was it in the original?
Yes, it's in our rules now.
And I'll give one more example.
Were they in the rules
Wait,
in
wait.
1982?
Wait.
Chuck, do you know that?
I'm not sure what, you're asking about the quorum definition?
Yeah.
I agree that that's governed by either
I'm
city
sure it
administrative
is, but I'm
procedure
wondering
act.
whether this has come down
It's-
since 1982, or there's been some
This is
change
our rule.
about the quorum over the years.
It wasn't in this law, it's not in the loft board laws, it's in the loft board rules, but it's also governed by.
I think it's part of the open meetings law.
Why are you asking that? Are you?
Well,
We're-
I
we're
mean,
actually
I'm curious
below that.
of when this was inserted and then why. Now, just to extend 1 second, hang on,
By the way, I'm
there's
sorry.
two other members
Mr.
of,
Mr. Yeah, Mr. Morrow, I mean, we were on another topic, and then we shifted there, and we hadn't decided that yet. And I will hold your point just a second. I want to make sure that we're all okay with removing that piece about the representatives, or if we want to stay or something, but we need to move on.
Okay, I want to give one more
And
example.
then I'm going to come back.
it's all right.
Because I think I have a semi-unique voice in that I'm a tenant, but I'm a public member. So let's say I got off the Loft board, and Chuck stays as the tenant rep.
Yeah.
And he has to go to Australia for sick relative. I hope that didn't happen.
Australia.
That'd be a surprise.
And he said, Julie, I have to be away. Would you sit in for me? And you know, your role is
Oh,
just
you
to
mean-
sit there. I would happily do that, and I think it would have some.
You wouldn't need to say that because you're
I
on the board
wouldn't talk.
already.
No, but I'm
No,
saying.
she's
I'm
not.
Oh, you're off the board.
I'm off the board. It's like 5 years from now.
Oh, I
I would be happy to sit here and not say anything but pay attention for tenants that I care about and report what happens, and I don't need to carry the whole platform and like.
Yeah,
do-
but your presence here by just sitting in that spot,
Yeah,
just to be viewed.
yeah, just to show tenant, I'm paying attention and repping us all right now.
But isn't it on video, it's on video.
I don't agree with that.
I agree with Julie.
But I mean, just the presence of a person who says they're perfect, but has no ability to say nothing? I mean, just to say, I don't.
Follow it. I mean,
To
these
your
guys don't
point,
even
Julie.
have a book. Like, they're looking at the book, but like, at least I'd be sitting here with the rule book and I could follow along.
So how would, I'm just curious, I mean, I'm not against what you're saying, I'm just saying, how would you report it that could be better reported
I would write
than
notes.
watching the video of the meeting?
Well, because you bring your
Well-
perspective.
And the,
It's a,
Well, and
okay,
there-
so then she goes, the next day, she goes and she has dinner with Chuck and she like,
here's
they
the
have a
debrief.
conversation.
Here's
It's
the
like,
email
this is
debrief.
what happened.
What you could do is Chuck would just get a video of this
Well-
thing. And I bet when this was here, there was no public meetings law that says you have to, is it public meeting law? that says-
Well, you did, yes, there was
There was-
public meetings law, and you have to have minutes.
Minutes, but you didn't
But
have
it's
to.
not the same.
It wasn't as
Not the
instant.
same.
That was a
Video.
council law about 5 years ago.
Yeah, it was.
Well, that has to be there.
Open
Yeah.
meetings,
Yeah.
open meetings.
Joe Brewer pushed that.
Yeah, but I just think, and I'm more for taking it out. Because I don't think in today's modern way of availability, almost instant communication, you could almost stay there and put this stuff on video.
one more point, I guess for a tenant or for a manufacturer, like if there was a manufacturing rep sitting here where Heather would normally be
Yeah,
there,
yeah.
I would be like, oh, there's some strength there. There's some power, like he couldn't make it to the meeting, but someone else is taking their time and sitting there. It would be the same message for a tenant or the owner or real estate rep. And I think that representation matters. It has like,
I
So
want you-
can I just say, the way that the rule is drafted now, you could do that.
if we pull this out.
No, if you left it, you could do that.
But I don't want them to take over like what he did.
No, but the
It was
rule
like-
says they can participate only to the extent permitted by the board. So the board could say, yes, we will let your substitute sit with the board, but they cannot say anything. You could say that.
Can I just say something else though? there's no other board that does this.
I know.
There's nowhere else.
No other board.
Why are we doing this? I mean, I've sat on a couple of boards. I can't just get up and say, listen, I'm not going to be here tomorrow. Put my friend there because, these board members, you all are vetted.
Yeah.
You're vetted, conflict of interest and stuff like that. And, why would you put somebody, you don't know what that other person, my friend, my closest friend, I don't know their background. Right.
Well, I'd like to make a couple more points, if I might. Number one, if you're in a situation, as we've been not infrequently over the past year, where we're meeting twice a month, and we may be coming towards some substantive votes.
Right.
To say, rely on the minutes and rely on the video, it takes a significant period of time to get even the draft of the minutes up and to get the video edited. So there would be circumstances where having someone be able to brief me or Mr. Carver or Mr. Hernandez would be beneficial. They could be sitting there, they could be sitting here. But I think, but obviously, the legislature mandated special interest representatives, which suggests that special interest representatives might have a slightly different role to play than a public member or an ex officio member, of which we now have two. So the other thing I would ask that we explore is maybe what should be looked at is whether the special interest members would be allowed to vote in absentia.
But you're not getting.
Without attending the
Without being
meeting.
at the meeting?
Chuck went skiing
Again.
in Vermont. His leg is in a cast. Why should he not be able to cast a vote?
Well, you mean attend remotely?
I don't even think the U.S. Senate does that, or Congress that allows you to
Oh, I
vote
don't
here.
have
about
Senator
that.
Conley.
No. But here's, I mean, if anything,
Soon we're all just gonna be a little
Okay,
talking.
I hear you, but we're not,
Can I just
Anyways.
remind everybody
We
that we
got-
promised to finish and
Yeah.
we're stuck? So.
so if we all agree, let's take
We're
this.
to finish 209.
I think
That's
we have to
true.
finish this.
All right, let's,
I thought we were gonna finish it.
Actually, I'm of two minds of this. For one thing is that all of us that are not special interests, we can take any position we wish.
Yeah.
We can take the landlord position, we can take any position we wish. So for us to take any special, for you to take Chuck's position.
When I'm
doesn't
off the
seem-
board.
When she's off the board. If she's not on the
When
board,
I'm
she
off the
said.
board,
She was just making a point.
when I leave and I'm off the board and I'm a regular citizen, I'm just saying, I would come in and sit there if you asked me to.
No, I don't think you could.
You know what, also, I just had a light go off mind. I think in this provision, maybe usurping the powers of the mayor. He
Ooh, that's-
appointed,
Well, that's
you know,
because, no, it's, but
he
no, but
appointed-
they can't vote, but they can't vote.
still,
So it's
still.
But on the other hand, I take the
Listen, I
I
would-
position, it's, people, they should be, with all possibility, should be here.
Yeah.
I mean, that's why,
Let's
I mean, when you get appointed,
Yeah.
you know that it takes place in a particular afternoon when you may be at work, or at least part of work.
Let's take it out, and.
So I don't know, and then as Chuck said, we lived without the manufacturer rep for years.
Let's take it out and just have, some attendance mandate as Mr. Roof said. But listen, we're not now, I'm saying, but I'm saying I would vote to just, let's take this out. I think that's the easiest way to get going on this today.
What do we do to, we haven't been voting so far. Are we doing
No,
a
not
straw
voting, I'm
poll?
saying, no, I'm saying, huh?
Are
You
we
mean,
doing a straw poll to see who agrees?
What?
Probably take a vote, I guess.
listen, if you take a vote, I can't have more than one decision. Otherwise, this goes nowhere, right? You only have 6 people. Can't we have at least?
Well, as the only special interest member present to comment on this, I would vote no.
To take it out.
Yeah.
And I would vote, I would walk out the door the second something like that happens again, that happened this summer. That was the most outrageous thing I've ever seen.
Can I lobby you in having this out?
You guys
That's
missed
what
it, but we had,
that's what
we
the
had a
chairman
lobbyist
is trying
step
to
in here and
avoid.
not stop talking, and there was a bill on the table in Albany, and it was obscene.
Can I just have a straw now?
Still makes me
And we can move on one way or the other, but I've made my point clear, that, how can I phrase this?
You would like it, Ellen.
Yeah. I mean, can I have a,
Same way you have the last time.
can I take a vote to see how many of you would agree to taking that piece out that says, representatives of special interest groups may, in their absence, designate substitutes to participate in discussions at the board meeting when the Loft Board by vote requests such participation. And the following, yes.
Can I offer a possible win-win for everybody? Can we see if we can just recraft that?
No.
No, you want it completely out?
Yeah, I see that out. Crafting it, it's going to take,
Should be out.
recrafting this is going to take a lot more debate and stuff like that. We really do need to move on.
I would rather we not take a vote, but make what I would say a ladies and gentlemen's agreement about
Okay.
it.
Can I have a ladies and gentlemen's agreement about
Okay.
this?
Mr. Barrow?
So it's a straw poll, Vanessa?
It's a straw.
In or out?
Out.
I have to go with out. As it exists.
I'm going out. I'm going for it out.
Delete it, yeah.
I think I'm ambivalent.
I made it clear, I don't
Yeah.
participate in straw polls either in the
Yeah.
private meeting or in the public meeting. You want to make a motion, and I'll vote, but no straw
Okay,
poll.
so,
Somebody has to make a motion.
somebody, Mr. Roche, please make a motion. No one's going to make a motion?
You're not gonna make a motion?
Oh, well, what if it gets knocked down?
No, it's not.
You make the motion.
Okay,
I'll
I make a
second.
motion, I
So you're making a motion to delete
special.
the language, the language on page 14, lines 25 through 29. Is there a second?
Mr. I was going to catch you there.
You can second and then still vote the other way after
No,
that
you
before.
can't do it.
You can
Yeah, you
absolutely
can.
do
You
that.
can.
Okay.
What
Mr.
is the motion?
The motion is
To
to
delete?
To delete the
delete
passage about
this,
special
just set the
interest
section going, the piece going from, it says in
It's on page 14, lines
25,
25
that
to
begins
29.
with the word representative and ends with vote.
Mr. Bowers?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
No.
Ms. Rosen?
Abstain.
Ms. Torres?
Yes. I mean, no, what am I saying?
Yes.
Yes,
Yes,
to
yes,
the-
yes.
Yes to the motion,
Yes.
yes to the motion to remove the language on
Yes.
page 4, lines 22 through 29.
Chairperson Consent?
Yes.
4 in favor, 1 against, 1 abstain, 2 absent.
You see, once again, as we don't, as the quorum requires 9 votes, this fails.
5, it fails.
Which is one of the reasons why I didn't want
So this is not going to hold up this rule.
necessarily to have a
It's not going to hold
vote
this,
on
it's
this,
not going to
Okay,
hold this
so it
rule.
stays.
rather than a simple agreement. So now,
No, it's.
So for now it
lacking,
stays.
lacking a full quorum.
This thing is on life support, Elliot, don't worry.
We can revisit it in the future.
Can we do
We're
that next
gonna
meeting?
do more rulemaking in the future anyway. There are a few open issues that we said we were gonna put aside, but we'll get this going and then we can talk about it again in the future.
It often takes us 3 or 4 meetings of talking before we.
But we gotta get going.
Okay, let's go. Just saying, we'll eventually get there, we always do.
All right, page 18, lines 7 to 10. An application for rent overcharges must be filed within 4 years of such overcharge. An award by the Loft Board for rent overcharges may only include overcharges within for 4 years immediately preceding the date of the application. So there's two issues here. Number one was the rent stabilization laws were changed from the look-back period from 4 to 6, right?
The statute of limitation is 4 to 6. The look-back period, there's no look-back in the sense that you can go first back to establish a rent.
Okay,
But
but it's
statute of
6 years.
limitations
You can
is
get
from 4 to 6.
So if you, under rent stabilization now, if you're overcharged for 8 years,
You can recover for 6.
you can recover for 6.
Yes. Which is the same as contract law, so statute of limitations, it makes sense.
And in rent stabilization for overcharges, is there trouble damages? No.
Willful overcharges.
Willful
Yes.
overcharges,
And I think
trouble
that's
damage.
limited to 3 or 4 years. I have to double check the time period, but it's shorter. It's not the full period.
And we have no trouble damages.
We have no trouble damages.
So you're saying that we should make it 6 within the 6 years?
Yes, within 6 years immediately
If you
preceding.
believe in peri materia, yes.
There's one other thing that Mr. Carver pointed out ages and ages ago, which I promised I would raise to the board.
Still has his voice on it.
Yeah, I promised I would raise it to the board when we revisited this, which is that the current rule says that overcharges shall not be awarded for the period prior to the date of filing of a coverage or registration application. Which, in a way, and we deleted that. I'm not 100% sure what we were thinking at the time that we did that, but it does make sense to have that in there because the owner wasn't actually obligated to freeze the rent until either of those things were filed. So I think we should put that back in.
And where did you delete it from?
So now it just says it must be filed within 4 years of such overcharge, and the award can go back 6 years. You could get 6 years worth of the application, but we should probably add back in, but you can't go back prior to the filing of the date of a coverage application or a registration application.
As opposed to the effective date of the law.
Well, but,
But you're not covered, if the unit's not covered, there's no,
so that goes to the fundamental, idea of, are you an IMD by operation of law, in which case you should have been doing everything right from the beginning? Or do you have to wait until the loft board or a court says, yes, you're an IMD, and then all of your obligations come into effect? And there isn't really an answer to that. It's two different philosophies.
When does the law says you become an IND, right? When
The law says if you qualify, you're an IMD. If your building qualifies, you're an IMD.
Well, when
And
does
you
the
have
loft board
60 days
say,
to register your
when does the
building.
loft board say that you're an IND?
no interest.
The
It
issue-
says, either you're registered, the owner registers the building, or when the board,
That's not what the law says.
Right, someone's saying, what you're asking you're asking the question wrong, right? So you're saying, when are you an IMD, and when are you registered as an IMD?
Right.
I thought you only became an IND when the loft board says you are, or when the owner voluntarily registers.
No, actually, the law, and this is 284-2, requires every owner of an interim multiple dwelling, every lessee of a whole building, part of which is an interim multiple dwelling, and every agent or other person having control of such dwelling shall, within 60 days of the effective date of the act which added this article, file with the loft board or any other authority, blah, 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 in conformity with all provisions of the law and rules. So actually, the way that the law is structured is, you owner, if your building qualifies as an IMD, you are supposed to, within 60 days of the effective date of the law, register your building and start legalizing. That's how the law is structured. But from a practical standpoint, it really doesn't work that way. Nobody's going out and looking for plants on fire escapes, as they used to.
Well, that's not necessary.
Well,
You guys.
We do.
so this is,
Upon request, we do go out.
so this
You
is
look for
the,
anything that's on
so
fire.
this is what Mr. Carver raised, and I thought, I promised him that I would bring it to you, and I thought that I should. So it makes sense to me that, when the loft board puts its imprimatur on it in some way, shape, or form, that should be the date. So you're filing your coverage application, you're filing a registration application, that's when your obligation to make the rent, to stabilize the rent, freeze the rent starts. So,
But when we look to what the rent should be, we look to the rent as of the effective date of the law.
yes, right. So it's just a question of how far back can you go back? Can you go back to before you file the coverage application? Should a tenant be allowed to recover a rent overcharge from the time period before they even file the coverage application? That's the question.
Sure.
Well, if you sign a lease in a residential, in an already residential building,
Right.
and you file for a rent history through DHCR,
Right.
and it's determined that the tenant before you was paying X and you're paying Y. Am I not making a case? I don't think I'm making a case, but I'm kind of thinking out loud. It's for the entire length of your possession of the apartment, but it looks back to when when the rent was legal for that unit.
It looks to the last reliable rent, whenever that is, if they can find one. It goes back, far back as the place, but it's a different question than statute of limitations, which is what we're dealing with. Like how far back can they recover?
Well, having taken the chairman's word that we would complete at 4:30, I have a 5 o'clock appointment. So it seems to me this is something where a little research would be helpful.
What are we researching?
Well, first off, in line 7 to 10 at the moment, have we changed 4 to 6?
Yes, we're changing 4 to 6.
On both line 7 and line 9.
Right, or is it just one? Isn't the first,
I think we could.
isn't line 7 the statute of limitations and line 9 the look back, or are they the same thing?
No, I think they should both be 6.
You know, it's the same thing that we're talking about statute of limitations on both sentences.
Okay.
There is no look back period for us, but that's just when it's, there's no.
Well, that's the issue, right? The issue, what we're debating is the look back.
No,
period.
how you set the rent is a different question. Like,
Oh, you said, yeah, you
So
said,
look back, it has to do with how you set the rent, which is not part of our issue.
So even if the rent was illegally changed 10 years ago by somebody else, and that other person was overpaying, and then you take over, or you get a lease and you're overpaying. No matter what the situation is, wherever it's determined the rent should have been started from.
Right, that's in the rent stabilized apartment, that's how they start calculating it.
Okay.
That's how you set the rent.
But then you only get back 6 years worth of my overcharge.
Right, yes.
So how far do we look back? Is that the question?
No, look back has to do with how you set the rent, which is not like a.
right, we know how to set the rent. The law tells us how to set the rent, right? The issue is, does the tenant get to go back prior to when they filed the coverage application? And getting a rent overcharge. So if the 6-year period, if they've only been a protected occupant for 4 years, right? Or they filed their coverage application 4 years ago, sorry, that's my 4:30 alarm. So the issue is if they filed their rent overcharge application and they only filed their coverage application 4 years ago, under the current rule, they would only get 4 years. If we change it to 6, could they go back and get the additional 2? And the rationale is, well, but they hadn't even filed the coverage application, so the landlord had no obligation to pay the rent, to freeze the
The
rent.
rationale is that it's de facto
Correct.
IRD.
I don't believe in de facto IND. I mean, it should be back to their coverage application.
buy that?
She don't buy it. She said you don't.
She said she'll buy
Oh,
it.
you buy it.
All right, so I'll put that, so I will put that language back in, okay? Okay. No, we're not done, but it's 4:30.
When do we get to
leaving.
do
Well, just maybe Mr. Lady
How
wants
much
to
more
put
do we
it.
have to do?
Point something
Huh?
out here or something.
When do we get to do?
when do we get to
You
finish?
want to pick someone out of the audience to
We'll
apply?
have to finish it, we'll have to finish it at the next board meeting. We'll have to finish it at the next board meeting.
After Casey.
Yes,
And we have an extra meeting scheduled in March.
in March.
So, wait a minute, so can we at least pledge, we're gonna do this at the very beginning, we're not going to do cases first.
No, you gotta do cases first.
How much?
This is the
What
public.
comes first? We'll make it a light calendar.
I think we're making.
We'll make it a light
I
calendar.
think we're making pretty good progress, considering the amount of time as a whole. I think with the engines have picked up pretty good.
Is that February, what, 20th?
Yeah.
Can I ask one question? It would be a open issue to me, but I don't know. You're probably gonna say that next time. But if, I don't believe in the rule that says like a tenant should have to share costs for like an owner's asset that they end up at the end of the day making a lot of money on. I'm just wondering,
Oh, no, that's not going anywhere.
is that a law?
Oh, yeah.
But
MPL
so would
280.
Would it, I know, but I'm just trying to learn.
Yeah.
Would that need to be changed at the legislative?
Oh, yes.
MPL, what is it?
280. Yeah, it's the loft law. It's the purpose of the, one of the purposes of the loft law.
Just to share the cost. It's not really funny.
It's not
funny. There's
supposed
only
to be
been one
funny.
case of it. But those of us that live in
No, there have been many
places that are
cases of
very
it.
expensive.
There have
It's like
been,
we're
there
looking
have
at
been many
tripling our
cases. There have been many cases where the owners have filed for costs. The unique thing about the case that you're thinking of is that they asked for financing as well. That was what was unique about that case.
Financing, yeah, like
Yeah.
if all of a sudden my rent tripled, I'd be out of here in a second.
Yes, I
Like,
can understand
I
that.
think most people would. So I don't think it's like I don't understand why tenants would have to take on an owner's financing and then they can sell the building for millions and you get nothing. I just don't understand that.
You
I've
get
never heard
a
of
legal
that.
rent
Does that happen
stabilized
in
apartment. You
rent
don't get nothing,
stabilization?
you get a legal rent stabilized apartment.
Once you're out of the system,
You get a legal rent stabilized apartment.
that's your product.
Yes.
For like $3,500 a month, it's not that great of a price. I was just saying, like, and then if it became $10,000 a month, but I'm going to Ohio, where my family is.
I
I'm
miss
just
you.
saying, like, that's like, makes it impossible to stay in the city.
All right. Well, the point well taken, I think the point here is what Helene's making, is just that we can't even consider.
Oh, that was all I wanted.
Yeah.
I just
Yeah.
wanted to know if there's a legislative.
Yes,
Right.
yes.
Because that could be worked on.
Yeah.
Albany's lovely this time of
Are they essentially? Oh, yeah, there's there. Okay, this concludes our January 30th, 2020 Loft Board meeting. Our next public meeting will be held on February 20th, 2020 at 2 p.m. here at 22nd Street, Spector Hall. Board members, please sign and hand in your attendance.